Hear ye, hear ye, hear ye. All persons having any business before the Honorable, the Justices of the Appeals Court, now sitting at Walsh in the Commonwealth. Join in. Give your attendance and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
I'll figure it out. I just can't get the plug in. Thank you. Thank you. Yep, good.
All right. Welcome to the Massachusetts Appeals Court on this Thursday, November 9th, 2023. I'm Justice Joseph Ditkoff. To my right is Justice John Englander, and to my left is Justice Maureen Walsh, and will be the panel for all the cases today. I know that we have a lot of experienced attorneys here, but I will go through the spiel anyhow. We have our clock here. It will start at 15 and start counting down. It will show green for most of the time. When it gets to 90 seconds, it'll turn yellow. When it runs out of time, it will turn red and start counting up. If the light turns red, you can finish your sentence, but please don't say anything else unless you're answering questions from a judge, in which case, please complete your answer. Please, there is no rebuttal in the Massachusetts Appeals Court. Please be aware that everything's being recorded. That's what that little symbol there means. And it's also being live streamed. We have read the briefs. We have gone through the materials. We understand your cases, and you'd be best off just jumping right into your argument and not giving us the background. All that being said, I will now call the first case of the morning, Commonwealth versus Middleton, number 23P86. Counselor, I just wanted to thank you for refraining from naming any of the victims in your brief, and just remind everyone that the name of the rape victim cannot be said in this court. Okay, whenever you're ready.
Thank you, Your Honor. Morning, Your Honors. My name is Edward Gaffney. I represent the defendant, Alexis Middleton. Mr. Middleton is appealing today the second denial of his motion for new trial. The first denial was vacated by this court, and then the court remanded the case to the trial court, giving the judge the opportunity to apply the appropriate standard of review. After that review, she denied the motion again, and that led us to this appeal. I cite in my brief several clear errors of judgment that I believe the judge made in weighing the factors relevant to the decision in this case. Among the most important errors, in my opinion, was her reliance on a fact that was not only not supported by the record, but it was contradicted by the record. The judge, in essence, came to the conclusion that the withheld evidence in this case really wouldn't have mattered to the jury. Because although this evidence of basically the incompetence of one of the DNA analysts, Hillary Griffiths, she and Rachel Chow were the two DNA analysts who worked.
I just stop you there.
Sure, Your Honor.
What document do you say should have been produced prior to trial that was not produced, other than the Vance report?
Okay, what document was the suspension memos?
There is a document called a suspension memo?
Well, I refer to it as a suspension memo. It's both Chow and Griffiths were suspended
in 2006?
2006, yes.
Okay, so they're both suspended in 2006. Was that document put in their personnel files?
I'm sorry, was it put in the personnel? I don't know. I assume so.
Weren't the personnel files produced prior to trial?
No. Although, actually, Your Honor, the record is not clear. I did not get my hands on precisely what was disclosed.
Hence the questions, because I'm really trying to understand, you know, the Commonwealth points out correctly, I think, that sometimes you paint with too broad a brush, because you talk about documents and things that are known about Griffiths after trial. In other words, documents after trial that say that she couldn't do X or Y. Now, those were not available prior to trial, right? So the document that was available prior to trial that would have led to the cross-examination that you say should have been available to you or to your predecessors was a suspension memo with respect to Griffiths and a suspension memo with respect to Chow?
Now, that's the documents I'm talking about. The evidence that I'm talking about was that Griffiths couldn't do her job and that her supervisors knew it.
How are you going to get at that without having the documents and having somebody to say it?
Well, we'd call her supervisors, we'd call Griffiths. It was Griffiths who said herself. Now, I acknowledge that the documentation...
But see, that's painting with a very broad brush to me, because, you know, you make an assumption that this evidence is going to come in, and I'm not quite sure how. So you're saying they would have called Griffiths...
Yes.
...and established what?
Well, that she...
Going to get on the stand and say, yeah, I was incompetent?
Well, she was going to get on the stand and say, at a minimum, what she said in 2008 when she was asked, and she said, I made multiple unreported errors with the knowledge of my supervisor.
But we're not retrying the case, right? You're appealing the denial of second motion for a new trial. And in that motion for a new trial, in the denial, the judge is clear that, and favorable to you, I would suggest, that despite the broad language of the discovery request, that this fit within a specific request for information, even though it wasn't necessarily even able to be given in a form before trial, you still get the benefit of that ruling. And importantly, I think when the judge looks at it and says, that evidence about Griffiths in particular, or Chow's, what you claim to be incompetence, could be used when the supervisor who testified, and I know you claim whether she independently reviewed and testified or not, to basically attack it through that witness, right?
Yes, absolutely.
So, you know, about calling new people or what have you, but I want to hear what the errors were. You're claiming there's an abuse of discretion by the judge.
Multiple.
How does the evidence come in through the supervisor unless the supervisor is established to actually know?
But the supervisor...
It's hearsay evidence, right?
I have evidence, I have documentation that two supervisors, these statements were made after the trial, but these supervisors state in 2008 they knew.
Does the supervisor who testified, whatever her name is,
Kaylin Drugan, yeah.
How do we know that she knew anything about the actual disciplining of both Chow and Griffiths?
I don't. She never testified to any of that, and the defense, I mean, they didn't know anything, you know, they asked for background information that was relevant to the trial, before the trial. They got nothing. They got nothing. And both of the people who did the DNA work were suspended for switching samples. I mean, you know, the memo that suspended Hillary Griffiths.
Back up. Where I missed that, I saw where they were suspended because in unrelated cases, there was some DNA in Chow's instance of her DNA in a sample, but switching samples, and I know she was retrained, but I didn't see any particular evidence of that, because you're not challenging, it seems to me, the accuracy necessarily of the DNA. Without finding where you came up with it, you're saying that the samples were mismatched and mislabeled, right?
Well, in the suspension memo, and this is at Record Appendix 170. That's the memo. 168 is the memorandum. I'm sorry.
68 is the.
That's the memo that suspended her, and then 170 is the corrective action plan. In 168, it goes into what she was being suspended for, and what she was doing.
Aliquots are not placed in appropriate tubes. Rows.
And the tubes were put in the wrong rows. Now, and an aliquot is I didn't know this until preparing for this, but an aliquot is the part of so you have a sample in a tube, you take a portion of that, that's an aliquot.
Outside the record right now when you're telling us this?
Say that again, Your Honor?
Are you outside the record when you're telling us this?
The definition of aliquot?
Yeah.
No. That's an aliquot is an aliquot. That's just, I learned the definition by looking it up. But aliquot is said in this in this
The
document.
word aliquot is said.
The word
The
aliquot is
testimony that this means that she might have switched actual samples of DNA, as far as I know, is not in the record.
Well, what-
You're telling us this.
What this says is she's being suspended because she needs to address skill sets to focus on tasks without sample mix-ups, as aliquots are not placed in appropriate rows and tubes. And then for her corrective action, she's to employ safeguards to avoid mislabeling, sample switching, and transcriptional errors, and to establish techniques that ensure accurate and reliable results.
Okay?
I mean, this is the record. She was suspended for being unreliable, for her efforts being unreliable. And that never got in front of the jury because it never got to the defendant. And in the case where the biggest part of this case was the DNA that was identifying Middleton as one of the perpetrators, the defendant, it was vital for the defendant to be able to present evidence to the jury that this evidence was not necessarily so reliable, especially given the fact that Kaylin Drugan got up there and testified that the crime lab was basically, you know, it was a paragon of reliability. Everybody was tested, everybody was extensively trained and tested, and Drugan herself, who testified.
We don't have the, at least I looked and could not find Drugan's testimony in the record. Is it here? Do we have Drugan's testimony?
In the transcript, yeah.
Yeah.
Oh, yeah.
Okay.
Her testimony, and I don't remember exactly where it starts. It's in trial volume 4, probably around 120 to about
Yeah, around there.
170 or 180.
Okay.
And on direct, she makes very clear that she did not review Drugan's work. She wasn't Drugan's
She didn't
supervisor.
review Griffith's work, you mean?
Oh, I'm sorry, Your Honor. Yeah, that's right. Drugan testified very clearly. She reviewed Chow's work, but she didn't review
But
Griffith's work.
what's interesting is Drugan testifies that before you start a procedure, a second analyst would come in and review that my samples were set up appropriately. Do we know who the second analyst was for Griffith or Chow, who made sure they were setting up appropriately?
No. The only other testimony, you know, Drugan testified that she was Chow's supervisor, but she said she wasn't present at the time that Chow did her work, or Drugan.
No, I know it's not in the trial, but you guys have the discovery on the test. Does it tell you who the second analyst was? And
No, I didn't. In the discovery that I received, there was nothing about this case. Justice Walsh made a comment that I wanted to touch base on, because there was another error that I believe that the judge made, was her characterization of this evidence, this withheld evidence, that these analysts, especially Griffiths, made mistakes in other cases. Now, the Commonwealth, in their memorandum, in the pages cited by the judge in her decision, says that these errors were made in other cases 6 times in 6 pages. That may be why the judge came to that conclusion, but it's not in the record. The record is that she made a handful of errors that led to her suspension, but they don't say what case they were made in. And then there's another
No
set of...
specific evidence that the mistake was made in this case.
No, Your Honor, but that's not the defendant's burden. At this stage, the defendant's
Well,
burden is...
you need to show that there's a reasonable possibility that it would have made a difference to the jury,
Yeah,
right?
that's
Okay,
right.
well, so that fact would have been useful,
It would have been.
right? But
surely
it hasn't
would-
been established. That's all I am asking.
No. I don't have evidence that they made mistakes in this case, but the record does not establish whether the mistakes were made in this case or not. What the evidence does establish is that she was making multiple errors during the time that she worked on this case.
There's no finding, and I don't see a contention in your brief, that there was intentional withholding of this information,
No, I have no evidence of
or that
intentional-
Drugan testified knowingly falsely.
No, Your Honor. The worst that can be said was that the the Commonwealth was asked for background information and that the lab did not come forth with what seems like extremely important background information.
So given the standard of review,
In this court,
right, tell me why the judge abused her discretion.
well, because she made multiple errors, in my opinion, multiple errors in judgment with respect to the factors that were relevant to her decision in this case. She relied on the fact that Drugan reviewed Griffith's work, and she didn't. She relied on the fact that there were these errors were made in other cases, and they weren't. She stated that during the robbery, that Nicholson, the co-defendant, called Tia, screaming and yelling about the fact that he and Middleton couldn't find any drugs or money. That's not what he said. He didn't mention Middleton at all. So there's a multitude of instances in which the judge basically erred in her characterization of the withheld evidence. And then when she based on those mischaracterizations, when she compared or when she analyzed whether the withheld evidence would have made a difference to the jury, I mean, if what the judge said was true, that makes a lot of sense. Like, why does the withheld evidence mean anything if we know, thanks to Drugan's review, that there were no errors in this case? But that's not what we learned.
Where's the judge say that
The
Drugan reviewed Griffith's work?
It's on page 6 of her decision.
Yeah, Drugan independently reviewed the work that was performed, particularly that of Chow.
Right, particularly. He reviewed the work in this case.
You read that as the judge making a significant mistake.
Yes.
That in fact, she was saying Drugan reviewed Griffith's work?
Yeah, that's absolutely true. And, Your Honor, not only does she, I mean, there's no evidence that Griffith's work was reviewed by anybody. But when the judge says she reviewed...
Wait, I thought there was evidence that it's reviewed because there's a second reviewer. Wasn't Judge Ditkoff just asking you about that?
Well, Judge Ditkoff was talking about Drugan's testimony describing how things went at the crime lab.
That evidence that in fact Griffith's work was reviewed?
Well, no, because the person who testified to it had no idea of whether Griffith's work was reviewed or not. I mean, we know what the protocols were.
Because she knew what the policies were in the lab.
Well, we know what the policies were at the lab, but we also know, thanks to the withheld evidence, that the policies weren't followed at the lab. I mean, we have evidence that a supervisor knowingly allowed Griffiths to make unreported errors. I mean, I would hesitate to rely too much on the policies of a crime lab, which the withheld evidence demonstrates the policies weren't followed.
All right.
I've gone over. I apologize.
But you were answering questions, so that was exactly what you should do. Any more? All right. Thank you very much.
Thank
This
you,
is
Your Honor.
very helpful. Counselor, whenever you're ready.
Thank you. Good morning, Your Honors. May it please the Court, Caleb Schillinger on behalf of the Commonwealth. I want to start just with the very last point that was mentioned before I forget it, which is it's incorrect to say there was no evidence that Griffith's work was independently reviewed. Drugan, who reviewed Chow's work, testified that Griffith's work was independently reviewed by Kristen Sullivan. Interestingly enough, Kristen Sullivan is the very individual that the defendant says was aware of Griffith's discrepancies and issues with competence.
Wait, it was Kristen Sullivan who reviewed who?
Kristen Sullivan, Your Honor, was the supervisor who performed the independent review of Griffith's work, and that is at pages 167 to 168 of the fourth volume of the transcript, and again at page 176. So Griffith's work was subjected to the same independent technical review.
Wow, but that's... I mean, this is the same Sullivan who was fired for making Griffiths babysit her children.
That was a different supervisor, Your Honor, Debbie.
Oh, mixing the two up. Thank you.
Yes. And so if you look in the documents that the defendant's principally relying on, there, supposedly, Kristen, the supervisor who reviewed Griffith's work, was aware of these alleged issues with Griffith's competency as the defendant has characterized it. So again, I don't think that the jury...
That's not a mischaracterization, is it? That there were issues with her competency? She was suspended because of her competency problems.
I do actually...
In 2006.
Yeah,
And the defense was not made aware of that.
She was temporarily suspended, Your Honor, that's correct. I do think it is an exaggeration to say that she was incompetent. There were discrepancies in her work that were noted, and as a result of those, she was temporarily suspended from handling evidence, a corrective action plan is formed, and once she has satisfied that and demonstrated competency and proficiency, she's allowed to resume evidence handling responsibilities.
Wouldn't the defendant have had a pretty effective cross if these documents that existed prior to trial had been produced?
So,
what he calls suspension records?
Yeah, and just on that point, Your Honor, because I know that you asked this question early on, I do want to emphasize what was available and what was not, what existed and what did not exist. So at the time of trial in March of 2008, the principal documents the defendant relies on did not exist, could not have been disclosed or used for impeachment purposes. That includes the State Police Investigation Report, which was dated January 2nd, 2009, the transcript of the interview with Griffiths, which was prepared in connection with that State Police report, and the April 2013
But you
email.
would have to reveal the exculpatory information in Griffith's head, right?
We would have to disclose the suspension memos. Those did exist, correct.
So if a member of the prosecution team is aware of exculpatory information, then that has to be disclosed whether or not it's been written down, right?
Correct, yes. If they're aware of it, if it's within their
And
possession.
Griffiths was a part of the prosecution team here, wouldn't you agree?
Correct.
So to the extent that she has exculpatory evidence in her brain at the time of trial, it had to be disclosed. I know there's no way you could do that, but that's how it works, right?
I'm going to agree in general, yes, Your Honor, with that. Again, there are the practical difficulties.
But still, there were documents. There were documents that had been requested, that existed, suspension memos, not produced.
Correct. Correct. As to those documents...
Was the personnel file produced and not these documents?
I believe the personnel file was produced, Your Honor, and that the request
And they
for background...
just forgot to produce the fact that they'd been suspended within the last 2 years?
I don't know, Your Honor. I didn't try the case. I didn't brief this appeal either. I don't know why that information wasn't disclosed. What I do know is there's been no accusation and no finding at any point that it was intentionally withheld, that it appears to have been inadvertently withheld.
Druger was Chow's supervisor?
Drugan was the supervisor who independently reviewed Chow's work, and she also reviewed a portion of Griffith's work.
Was she a supervisor of Chow? So that it's unquestionably the case that had they known, they could have got from Drugan on cross-examination, yeah, Chow's been suspended.
I don't know, Your Honor, if Drugan was Chow's direct report supervisor at that time. I don't believe that she was, because I think she indicated she was put into an administrative supervisory role later on in 2006 after the work in this case had already been performed. But I don't know for certain.
But in any event, I mean, if we're reeling back the tape, right, and trying to say at trial, if Drugan was on the stand testifying, and even if she independently analyzed the substance inside these vials, defense counsel was claiming it was misidentification, right? And defense counsel now, with the information that had he known at the time of trial, could have said, you're basing your evidence, your independent review, on work of somebody who's been
Only if you know.
suspended for swapping or for being incompetent, right? I mean, there's a possibility that when she reviewed it, that she could be at least impeached on the underlying fact that her analysis is only as good as what she has in the tubes before. So if somebody down the chain switched inadvertently the two co-defendants' name tags, because this is a mislabeling case, it would affect her ability to say to the jury, that, yep, this DNA strand belongs to the defendant, right?
Right.
And that's
Correct.
what the judge said in the motion for a second, in the denial of the motion for a second trial.
Correct, Your Honor. The judge found that this could be brought out on impeachment. Again, and the issue is, the potential utility or force of that impeachment. And again, would argue here that the value of this would not have influenced the jury or really moved the needle for all of the reasons that the judge addressed. Again, one, we're talking about suspension memos. There's no evidence that any of these discrepancies underlying the temporary suspensions related to the work done in this case, or even occurred during the time frame that the analysts were performing work in this case. In fact, I think it's clear from the letter that Chow wrote back concerning the suspension that no, that work was performed or those discrepancies occurred after all of the work had been completed here by March of 2006. The case of Courtright, it was a discrepancy that had nothing to do with the work in this case. And I think the really important point too is the fact that we have this independent technical review that's being done by Drugan. And it's not just a rubber stamp, as the defendant characterizes it. She reviewed all of the underlying data.
No, but it's really not the data here, right? I mean, it's not the scientific DNA strands and all the rest. It's that somebody swapped the tubes or mislabeled the tubes and apparently had some issues in the past. So while you can say those are unrelated, if somebody keeps swapping the samples in other cases, isn't it fair game when the defense counsel whole case really hinged upon identification?
Correct, Your Honor, although as the judge pointed out, right, the argument of swapping tubes didn't really serve the defendant's interest in the end because their fates were so closely tied together.
But they
as
wouldn't
co-venturers.
necessarily have been, would they? I mean, if this information is distributed prior to trial, as it should have been, right? I don't really hear the Commonwealth. Can we get agreement on that? Commonwealth agrees the two suspension memos should have been produced prior to trial as exculpatory evidence under the circumstances.
We don't dispute that, Your Honor.
Okay.
Correct.
And that's a constitutional violation?
Yes, subject to the standard that we're dealing with here, yes.
So if that evidence is produced, the most important evidence against Middleton, nothing puts Middleton at the scene of the crime other than his DNA.
No, there's circumstantial evidence, Your Honor. There was the cooperating witness's testimony of being in the car with the co-defendant.
Prior
and the
to
defendant,
and post.
Prior to and afterwards,
But
exactly.
nothing puts him there at the scene of the crime other than his DNA when the crime is being committed.
Correct.
Okay, so now Middleton's lawyers got this opportunity to say, hey, it wasn't me. They didn't know what they were doing with my DNA. Maybe there's an entirely different defense that's created.
I don't think so, Your Honor, because again, all the data here had been produced. They had an opportunity to review it with the DNA expert, and they didn't challenge the accuracy of the data. Instead, the theory of the defense was not that the tubes got switched necessarily, but that it was an entirely different third party whose buccal swab had been taken by the detective, and the detective mistakenly thought he had taken it from the defendant when in fact it was some other individual.
They did that because they thought there was sufficient evidence to place Middleton at the scene of the crime. So saying it wasn't me, it was the other guy, doesn't help Middleton because he's a joint venturer. But if Middleton instead has evidence that the DNA was completely messed up because these folks didn't know what they were doing, maybe he goes a different road entirely. Or am I crazy about that?
I don't think so, Your Honor. I mean, they did touch a little bit upon, what was done, whether procedures were followed, et cetera. But again, the issue is, with this information, right, would it have influenced the jury? And again, because of the second layer of review that you have here with the independent, the supervisors performing their independent review, I don't think that it would have that influence on the jury. And actually, I think that there's a serious risk of it backfiring if you were to use these materials on impeachment, because the documents show that, in fact, Griffiths and Chow's work was being closely scrutinized. And where there were discrepancies, they were flagged and they were addressed and they were dealt with. And so if you open the door to give Drugan an opportunity to talk about that on redirect, right, it may actually bolster rather than undermine her testimony as to the controls being followed here, procedures being followed,
So
and
if
would lend more
Middleton had
credence to the
pointed the
DNA
finger
evidence.
at Nicholson or whatever his name is at trial, that has the potential to backfire because the Commonwealth can respond in a way that just bolsters the evidence against both of them.
Yes, Your Honor. Unless the panel has any other questions on that, I was just going to very briefly address the motion to strike and the issue concerning the next cell phone, if the panel would like the Commonwealth to.
If you want to.
Just very briefly, Your Honor, what I understand to be the dispute is the defendant says there was evidence that the defendant was arrested with a Nextel phone. There was nothing to connect that and suggest that it was a Nextel phone belonging to the co-defendant. There was actually additional evidence that the defendant did not have any Nextel numbers or accounts registered to him, and so that in combination with obviously the close association between the defendant and the co-defendant. And just the last thing, Your Honor, I know a question is coming. If I just get this out and then I'll answer it. I would point the panel to page 86 of the 5th volume of the transcript. This is closing arguments, where the defendant conceded there was no phone registered in the name of Mr. Middleton at all. What happened was that 16 days after this incident happened, when he gets arrested, Mr. Middleton is found with a phone in the name of Donnell Nicholson on his person. So I think it was a fair inference that the Nextel phone that was found on him belonged to the co-defendant.
But how do we know that the phone that was seized from Middleton is the one that has all these incriminating calls? I mean, I don't really think it matters too much whose name is on, but we know one of the phones has all these incriminating calls at the right place and the right time. Is there any evidence that it was that phone? I didn't see it.
I don't think there was evidence, Your Honor, as to the specific telephone number of the phone that was found on the defendant when he was arrested.
Okay.
At least I did not see that in the transcripts.
All right.
Thank you.
Thank you very much. Thank you both. This is a tough case. It's been here before, and we really appreciate your briefing. Well, your briefing and your predecessor's briefing and the argument you gave today. Thank you. All right, I'll call the second case of the day, COMMONWEALTH versus CINTRON, 23P250. Whenever you're ready, Counselor.
Good morning. May it please the Court, Catherine Sullivan Ledwidge, on behalf of the defendant, Mr. Carlos Cintron. The first issue raised in my brief that I was going to address is the motion to suppress, and it's the search of Mr. Cintron pursuant to the any person present portion of the search warrant. I argue that because Mr. Cintron was standing in the driveway at the time the police arrived to execute the warrant, that he was outside the curtilage of the house. The house authorized the search of the house. The target of the investigation of Mr. Christopher Gaspar and any person present.
Didn't actually say the house, right? It said an address.
Yeah, so it said an address. I have that right in front of me because I figured that would be an issue. It gives an address, and then it says, so 574 West Yarmouth Road, West Yarmouth, Mass, dash, a single-family Cape-style residence, period. So then it goes on and it describes the residence. And the reason that it describes the residence, I would say, goes to particularity. And so it's to identify for the police the particularity of the house. It's not to expand.
Is it your position that they had no authority under this warrant to stop someone who was just outside the house?
Correct.
Why would it be reasonable to read it that way in light of the search warrant, which says that the transactions were taking place outside the house? The warrant affidavit.
Right. Well, it doesn't say where outside the house. And I think that it would cover the yard if that took place, if they described with specific information where exactly outside the house. When it says he exited the house, the surveillance information in the warrant described people coming up, briefly either entering the house and briefly leaving and immediately getting in their car and driving away. Some people, it even said, had their motors running while they ran up and got their stuff and left. But the control buys, the descriptions of those, each one repeated itself, as unsurprising, that, it was just like cut and paste just about from each one. And it just said, the informant walked up, Mr. Gaspar left the residence, a brief exchange took place, and he left. So where?
So if that was occurring when they were executing the warrant, your position would be they couldn't they couldn't search the person who was outside the house because they were outside the house?
Because they were outside the curtilage of the house.
Well, where does the word curtilage come from?
Well, the word curtilage comes from old common law to describe the area adjacent to the house that is usually set off by an enclosure, and that normally sets off
Word
what...
curtilage comes from the Fourth Amendment cases that talk about where it is that someone has such a reasonable expectation of privacy that you need to get a warrant.
Correct, but in...
Why would we take that concept and apply it to construing the scope of a search warrant?
Well, it is...
That's actually been obtained.
But it does... This curtilage is used in a different context here, and if you see the Commonwealth versus Whitty, the SJC just decided this, and it was dealing with the driveway. So curtilage is used in a different context.
But Whitty is a case about whether or not they needed a warrant, right?
Well, there's...
Not about the scope of a warrant that had actually issued.
Okay, I actually have a bunch of cases on this point, so...
Well, there's one that you cite in your brief, which says that it's helpful. It's the case written by Judge Ireland. I think it starts with an M, like Mc something.
McCarthy?
Yeah, I think so.
Right.
It doesn't say that you have to define it in terms of curtilage. It says curtilage is helpful. It's a helpful concept for defining the scope of the warrant.
Okay, and if we look at
You understand my point, I hope.
I do understand your point.
I mean, aren't we really just construing what the scope of the warrant is here?
Yes, but I would argue that just as in McCarthy, we are defining the scope of the warrant, and where the warrant says in the house, and where the police understand that it's in the house, as they, I am analogizing it to a McCarthy argument where it is helpful to define where they can search, and the judge relies on that in her findings and her conclusions, that because he's on the curtilage, he falls under the any person present portion of the warrant, and I'm saying that's wrong, where the driveway is outside the curtilage.
Counsel, you can't think that a driveway is inherently outside the curtilage.
No, you have to apply the foredone factors
So
and applying those.
Who had the burden of proof at this suppression hearing?
The Commonwealth.
Why would the Commonwealth have the burden of proof? For a warrantless search, the Commonwealth has a burden of proof, but I thought for a warrant search, it's always the defendant that has the burden of proof.
Well, I think it's still the Commonwealth's burden to show that their search was within the scope of the
Do you
warrant.
have any case, there's certainly cases that say in a warrant search, it's the defendant's burden to show that there was a problem. Do you have any case that says in a warrant search, it's the Commonwealth's burden?
No, and she asked each side for cases as well, and they didn't have cases.
Speaking of what was asked, at the beginning of the hearing, your predecessor seemed to argue not that the search happened outside the curtilage, but that you can't search the curtilage. The search warrant doesn't make mention of curtilage, and then in the closing argument, the same thing. So is there really an argument here that it wasn't in the curtilage, as versus whether you can search the curtilage?
Right, he said you couldn't search outside the house, but when I did my research, I found that there were cases that talked about curtilage, and McCarthy is one,
I'm sure that's
Fernandez is
true,
another
but if that's not the argument, if the argument below was you can't search even curtilage, you can only search in the house, then how can we come up here and say, well, if we had made a different argument and told the Commonwealth they had to prove curtilage, that we would have won? We don't know what would have happened in that circumstance.
Well, we do know what she ruled, correct? And she did rule that it was within the curtilage, so I think her conclusion in the end is that it didn't matter because he was within the curtilage. In other cases, they do specify curtilage versus house. They would say the house, curtilage, vehicles, things like that.
Let me just ask a different question. The police approach, they have a search warrant in hand. They're executing, we'll just assume, a lawful search warrant. And it allows them not only to search the house, but any person's present. And there's a person present who walks out of the house and says, oh, this looks like a bad place to be right now. I better get in my car and go home. To me, it's covered within the search warrant. Whether they're in the curtilage, whether they're, because they were in the house, and the search warrant allowed the officers to search anyone, any person present in the house. They're executing the search warrant, and the person walks out of the house. I don't see how you get around that argument. So I don't really care whether it's curtilage or not on this analysis. The other analysis, I do care with the done factors, but this one,
Because he entered, according to
because
the
the police are executing a search warrant, and they lay eyes on him, and he was in the house.
Well,
And they have the authority. So just because they run out the back door and out to the backyard, that means they can't search him? They're allowed to search anyone that was in the house.
I guess my response to that would be that
Different from Girl Scout cookie walking up the driveway, police can't tackle that person, right? We know, because it doesn't apply with the search warrant. This person was in the house, right?
Yes, but,
But what?
the only difference I would say is that he doesn't fall within the brief visitor foot traffic, per se.
That
He-
wasn't what
Because he
was
stayed out in
subscribed-
front?
Because he was doing something with the car and he was
Wasn't
there.
what was subscribed in the search warrant, though. It didn't say only we could search people who are brief visitors. If a little granny was in the house at the time, she could be searched. Because-
Sure, if she was in the house.
Right, little granny walks out of the house. What's the difference?
Well, we find out at the trial that his friend, who he was with at the time, standing in the driveway, never searched, never approached, nothing.
Okay, but, I mean, this isn't a discrimination case, right? I mean, say, there are gradations here, right? So the police come up and there's a guy standing on the sidewalk. That's one gradation. You would say, you can't search him, he's not present. He's not a person present. the police come up and there's a guy standing just outside the front door. The police come up and they see somebody who's been inside the house and has now walked outside the house. They're supposed to just let him go? They have no authority to detain him? Is that your position?
I don't think they have I think if they had more, I don't think they have enough under the warrant. I think if they had raised a different justification.
The warrant says any person present, and he was a person present. He was inside the house at the beginning of this process. So why doesn't he fall under it?
So if he had,
No, he is present. He's in the house. By the time they actually search him, he's not only outside the house, he's trying to run in the street, but he's inside the house when the police start their process here of execution. So why isn't he a person present that can be searched under the warrant?
my response would be that he's not present at the time of execution and announcement. He's outside in the driveway.
I'm trying to figure out, what is the moment you think matters? Is it when they announce police, search warrant? You say execution, but there's a whole process of execution that goes on for hours.
For me?
Yeah, no, what do you think the moment is that
I
matters for
think
person
that
present?
otherwise, why not take the,
No, which, is it the announcement is the moment? What do you think the moment is?
I think it's when they get to the house and then, when they get there, when they walk out, that's when they announce it. If he's not on the curtilage or in the house,
They'd gotten there while he was still in the house.
then he could be searched.
But that's what happened here. The police got there while he was still in the house, and they watched him exit.
Well, not when they were executing the warrant. That would be my position. And that he obviously had a different reason for being there than the brief visitors.
And what do
There are
you
no
think
other
is
questions.
what do you think is executing the warrant? When you said they weren't executing the warrant, but in your mind, what is executing the warrant?
When they get to the house and they start searching the house, when they show it to the occupants inside the house.
I'm sorry, I just didn't hear that last.
The residents, I mean,
You said something, the occupants, I just didn't hear the word you said.
when they knocked on the door and they, announced at the time and they walk right in. And he said he saw the target's girlfriend standing there.
Okay.
To me, that's the execution. Thank you.
Thank you very much. Whenever you're ready.
Morning, Your Honors. May it please the Court. Rosalyn L. Corey for the Commonwealth. This is a relatively straightforward case, and it is the Commonwealth's...
And maybe not. Is the Commonwealth's position that the language persons present is limited by the curtilage?
limited to...
Was the search warrant? I read your brief to suggest that you accept the proposition that the persons present language is subject to a limitation that can only be executed in the curtilage of the house.
So the language of the search warrant refers to it as the residence, and that's what it was referred to, I believe, during testimony. There were times when they referred to it as the house, but the description is of a residence, and the search warrant, as was discussed a little bit earlier, does describe a larger area than just the home itself.
Is that larger area limited by the word curtilage, as curtilage is defined in our case law? What's the Commonwealth's position on that?
On the definition of curtilage, or on
whether it's limited by the concept of curtilage, so that we have to look at the done factors and decide whether this person was inside or outside the curtilage of the house at the time that he was detained.
Yes, and I think that the any person present language does sort of change how the done factors are thought about, because as was pointed out, this was someone who had been in the house. This is someone who...
What case would put... Why would we do that?
Can I just interrupt for a moment? The done factors talk about curtilage.
Yes.
A separate and distinct issue from any person's present warrant issue.
Yes.
It's two separate, it's not any person's present in a curtilage and the done factors. Done, curtilage. I heard your argument to be any person's present. He was present.
Yes, and I would agree that that was the thrust of the Commonwealth's argument. That's why I would say that it would sort of change the application of the done factors, because the done factors apply.
I'd just like to get away from the word curtilage. But
I would also like to get away from the word curtilage, Your Honor. I'd be happy to talk about.
Because I don't think the cases about curtilage are about an entirely different issue.
I agree.
Okay.
And
That's not what you wrote in your brief, and that's why I was trying to understand what the position of the Commonwealth was. Commonwealth seemed to accept the notion that McCarthy limits this person's present concept to the concept of curtilage, and then we've got to go back and decide, well, is the driveway within the curtilage of the house so that you have a reasonable expectation of privacy? Why are we doing that? Why aren't we just construing the scope of the warrant?
Then I apologize for the lack of clarity in my brief, Your Honor, but absolutely, I think that the crux of the issue is whether it's, an appropriate any person's present warrant. The challenge that arose at the motion to suppress was based on the defendant's presence or absence within the curtilage of the home, which I think is why we've sort of ventured down this route in terms of brief writing and discussion. But at the end of the day, it was a warrant that authorized the search of any person's present, and the behavior of the defendant that was witnessed.
Any person present where?
Right.
Sorry?
Any person present where?
At the place to be searched, which was the house on, I think it's...
And the sidewalk? If he's standing on the sidewalk and he's never been inside the house,
No, Your Honor.
that's no good. So the difference in this case is what? Because he was
difference-
basically standing on the sidewalk,
Well, no, he's in the driveway of the house. He's on the...
which is how many feet from the, I don't know if there is a sidewalk here, but it's how many feet from the front of the road? Do we even have evidence on that?
I don't believe that there was any testimony on the distance between. But if you look at the language of the search warrant, it describes the driveways as being to the side of the house. It describes access to the door, or the main door of the house as being in the center of the house. So it's not as though this is a case where there is only one option for people to access the house on innocent business, and that is through the driveway.
And counsel, the record's clear. Defendant was in the house, right?
Yes.
So if we were to accept your sister's argument, then anytime police go up to execute a search warrant, 5 unmarked cruisers come to a driveway as they're walking out, and the whole house unloads with people running for the hills. They can't stop them because they haven't executed, even though they're in there, right? I mean, that's the difficulty of accepting that argument.
I would agree with that. I think it turns the execution of a search warrant potentially into a game of tag, which is sort of...
Even if they were like 100 yards down the block because they were really, really fast. If they'd been inside the house, presumably you could still...
If
they're outside the curtilage, right? They're 3 doors down.
If they...
But you got to be able to execute the warrant on them.
Right. If somebody who was in the house at the time it was executed took off down the street running...
At the time it was executed, though. And that was the discussion I was having with your friend. What is at the time it's executed? Your friend says when they start yelling police.
So I took that to understand that it's the defendant's position that when the officers arrived on the lawn of the house and identified themselves and ordered people to stay, that was the moment of execution.
Well, what's your view as to what the execution is, the time in which it matters that you're present?
Well, I think Your Honor referenced that execution of a search warrant is a process that can take substantially longer than you would think just, by...
How do we know that is really, I think, what Justice Ditkoff is getting at?
I would say that...
Because they had somebody staking out the house for a day before, so anybody who was present a day before is searchable, even if they're now in Lincoln, Rhode Island?
I would disagree with that. But when the named target of the search when the named target of the search warrant left the home and was apprehended, I would argue that that is when execution began, because that was the first part. They separated him and then were bringing...
Wait, so the execution began when they stopped the target?
When they stopped the named target of the search
But
warrant.
isn't the defendant outside the house by that point?
I believe he had exited the house. He had recently exited the house, but he remained on the property. He remained, potentially in transit. If the defendant had left...
So in your view, that the fact that he was inside the house...
Yes.
Before the target was stopped doesn't do anything?
It's, well, I believe it helps the Commonwealth's case, because
How?
as argued, if we move away from curtilage entirely and look at other bases upon which to sustain the judge's denial of the motion to suppress, this is someone whose behavior mimicked, almost to the letter, the behavior observed not only during the controlled buys, but during the observations of, or the surveillance of the property. So he arrives in his car, he makes a brief entry into the home, and he returns to his car. The only
And
difference
then
here.
he stays there, which is totally different from anybody else
Right,
they've
he
seen
lingered,
before.
but
Now
if
he's loitering in the front yard.
And so as he's loitering, the police arrive to execute a search warrant, and he, as opposed to doing what his companion did, which was to remain in place and acquiesce to the orders of the police, he took off running, which it's been long established in the Commonwealth that flight is a factor that can be considered for
reasonable suspicion,
Exactly.
probable cause stops,
Different argument.
right.
not warrants.
But these are the facts that were before the judge. So even if we set aside the motion to suppress, there was, or the questions of curtilage and.
That argument made to the judge? It was a search incident to arrest?
I don't think it necessarily has to be made to the judge. It's a question of whether or not the facts before the judge would support this finding on an alternate ground.
Right, but when the judge isn't asked to make a finding as to whether he was under arrest at the time, we don't really have the facts from which we can determine that it was a search incident to arrest, do we?
Well, the facts before the judge were that he had been, that he ran into the road, and at that time, the testimony from the officer was that he was under arrest for disorderly. So,
But the judge didn't find whether the search occurred before or after he was arrested.
well, I think the judge used the language in her decision, I think she said he was apprehended in the road, and the definition of apprehended both in Black's and in Merriam-Webster is to arrest. And the judge then says that he was searched after that, after he was apprehended. So to me, that read as a search incident to arrest. If you look at page 31, I believe the exact language is, at that point that defendant CINTRON began to run, he was apprehended moments later while running into the street. He was handcuffed, brought back to the residence, and searched. And if there are no further questions from the panel, the Commonwealth rests on its brief. Thank you.
Defense, Ms. Sullivan, Ledgewood, can I ask you one more question? I'm sorry. Are you challenging?
Get away that easily.
Are you challenging the disorderly, the filed disorderly charge?
It's guilty filed.
Are you challenging it?
I don't think I
asking
can
for-
challenge it, right, if it's filed. I understood always that you couldn't challenge on appeal a case that's been filed.
All right, but so you're not. We don't have to worry about that, is what you're saying.
Didn't think I could.
Okay. Sorry about that. All right, calling the third case, 23P268, Commonwealth versus Dick and others. Counselor, whenever you're ready.
Thank you. Good morning, and may it please the court. Kaylin Campbell appearing as a Special Assistant District Attorney on behalf of Plymouth County District Attorney's Office. We ask you today to reverse the allowance of the defendant's motion to dismiss, as there was probable cause to support the indictments for human trafficking in this case against each of the defendants. Now, I'll start with the judge's decision, which is notable because the judge did not rule that the defendant's behavior in this case was not covered by the human trafficking statute. The judge does not address that in his opinion. The judge merely found that because there wasn't an actual victim, there wasn't probable cause.
Was an argument made below, and I should know the answer, but I don't. Was an argument made below that it's not within the language?
Yes.
Okay.
Yes. I believe each of the defendants, I think but for two, they had it in their specific pleadings, but then the other defendants asked to incorporate the arguments of each defendant, so I believe it's covered. It was made below for that reason. The Commonwealth will address it. It is this offering to pay money for prostitution is covered by the human trafficking statute. I think it's covered by the plain language of the statute.
Well, maybe my colleagues may have a different, so we're talking about the issue that the judge did not decide right now, right?
Correct, and the reason I'm doing that is because the defendants have spent so much of their brief talking about that specific issue. I'm happy to move to the
Well,
the
they
issue that
talk about it in part. I'm fine to be here, so let's talk about it for a moment. What was their probable cause in the evidence before the grand jury that the people attempted to recruit, entice, harbor, transport, provide, or obtain by any means?
So certainly, so I think it's the critical language is attempts, and I think it's both entices.
Well, no, I got the attempt part.
Okay, correct. I think it's entices or obtains by any other means.
So this is enticement, responding to an advertisement that someone else has placed.
I believe it's not just it's responding to the advertisement, but then it's the conversation, the text messages that happen between the two people, and those are in the record and were before the grand jury. So
could you walk through each of the four and tell us where you have the specific intent to obtain or specific intent to entice, at least at a probable cause level?
Certainly. So each of the four, if you look at the presentment to the grand jury, are almost identical in that there's a back page ad which is posted. Each of the four respond to a number that's on that ad. There's then a conversation via text between each defendant and what happens to be who they believe is a person trying to sell themselves, but what is a state trooper. The specific intent is that exchange right there, which is, what are you offering? What do you like? What are you looking for? What's the price? And that it's that conversation, it's that negotiation, which I believe would be enticement.
We have cases that define enticement?
Yes, we do have cases that define enticement.
And it's enticement to respond to someone else's ad. Someone else presents an ad that says, I'm offering sexual services. Person responds to that ad by saying, yeah, I'd like those. And that's enticement?
I think it's different than that. The person responds to the ad, and then the person says, what are you looking for? They say, I'm looking for, and each defendant says a different thing, but they list a sort of sexual act that they're looking for. Some even say, will you do this? They say yes.
So it's the identifying the act is enticement.
I believe and to get back to your original question is there a case which defines enticement? Yes, Dabney does. It says
Sorry? What's the case?
Dabney. It's cited in my brief, but it's 478 Mass, and the specific pin site is 856. And it says, and I'm quoting, one may entice, for example, simply by making an attractive offer. Similarly, to recruit means to hire or otherwise obtain to perform services, to secure the services of another, to muster, raise, or enlist. So I'd say it's not just enticement right there. The recruiting is just to hire, which at the point that there's a negotiation as to, I'm looking for these specific services, here's a price, there's an agreement to meet, I'd say it falls under that definition as...
Would you agree with me that the application that the Commonwealth is seeking here is certainly not in the core of what the legislature was trying to go after with the human trafficking statute?
I would disagree with that.
Really? What evidence do you have that indicates that?
So I would cite specifically to Dabney, which talks about the statutory legislative intent, which quotes Governor Patrick, which he says it was to change the focus of police and prosecutors from targeting prostitutes to going after the men who pay for sex with them. That's the first thing he says. And the pimps who profit from those transactions.
He wasn't talking about, as far as we know, this specific subsection, but the whole bill, right?
He was talking about the whole bill, but I think the bill is, and if you look at it, it's designed to fill gaps.
So what the governor says about the bill, which he didn't, it's the legislature that wrote the bill, that's now legislative history because the SJC quoted it?
The SJC said it was the legislative intent. So to the extent that the SJC believed that the governor's statement about the legislature's enactment of the bill, yes, I believe it's now precedent that that was the legislative intent. But more than that, I think if you look at the McGee case, which is the first case which interpreted the human trafficking statute, in McGee, it talks about what the human trafficking statute was intended to criminalize, and this can be found on page 418. That's the specific pin site. The site for McGee is 472 Mass 405. But it's talking about forbidding individuals from knowingly undertaking specified activities that will enable or cause another person to engage in commercial sexual activity. And I believe responding to an ad, because but for someone responding to that ad.
That's a quote from another SJC decision?
McGee, correct.
Okay, so that's the SJC's gloss on the language? Is that what you're saying? It's not legislative history. It's the SJC's gloss on the language.
Yes, to
I'm
the.
trying to understand what we're citing, that's all.
Well, I believe that the SJC stating that the legislative intent is X and that the intent of the bill, if you want to call it the gloss, the SJC's gloss on it, I would say it's the precedent as to what the intent of the bill was. But I'd also say that it covers this type of behavior.
But the SJC has never addressed what you're trying to do here. They've never addressed someone who's responding to an ad
They have not.
for human trafficking.
No, they have not. They have not. But I think if you look at the SJC's precedent and their interpretation of what the human trafficking statute was supposed to prohibit and criminalize, that this behavior falls into that. Specifically because, but for someone responding to this ad, there would not be any engagement in the commercial sexual activity. And really, looking at the human trafficking statute so narrowly would defeat the purpose, which was to fill gaps and, as the SJC stated, to combat the very real problem of human trafficking that exists in this Commonwealth.
Yeah, but when I hear the word human trafficking, I think of somebody who's making money off of it. The defendants here are not making money off of it.
They're not, but I'd say that
Not getting a thing of value for
the
them.
language is not that narrow. The language is broad, and the language is broad for a purpose. I'd say that the SJC has recognized that it's broad for a purpose. The legislative intent has recognized that it's broad for a purpose, and for that reason, there is probable cause to believe that this behavior falls within the human trafficking statute.
5-year mandatory minimum.
Correct.
And you'd agree with me that there are other statutes that address this type of criminal behavior, correct?
There's General Law 272, Section 53A. It's interesting because I think Dabney provides, and McGee case, provide a good corollary in that just because there happens to be an existing statute which is similar to the statute that exists does not mean or negate probable cause.
Agreed, but generally speaking, the legislature generally doesn't enact a new law when one already exists that covers the criminal behavior of certain actions that they're looking to punish. Now, they may change it from a misdemeanor to a felony, et cetera, but when they're looking at a different type of crime, interesting to me on the argument that really isn't before us, but is now before us, is the idea of who has to do the enticing. Because in the way that I analyze this, it seems like if there was enticement, it was done by the police, right? I mean, they're the ones putting up the back page ad and trying to lure individuals to take the bait, right? And so to call negotiation over, I'll just call it broadly, services or prices, doesn't seem to me to fit within what my kind of reasonable interpretation of the word enticement is. In fact, if there was any enticement, it seems like it was on the Commonwealth side.
And maybe my focus on enticement was the wrong word to first focus on. I think it falls into any, I think if you look at the Dabney language, I think it's
Which
not.
word does it fall into? If it doesn't fall into, you said recruit? Doesn't what Judge Walsh asks?
No,
apply to the word
well, if you
recruit
look
as well?
at the definition in Dabney that the SJC says for recruit is to hire or otherwise obtain to perform service. Here, these individuals definitely hired another individual to obtain those services. I think based on the SJC's articulation of that definition, it falls in that. I think also that obtains by any other means, I think it falls under that word as well.
Because that's broadly written? Because of the word obtain?
Correct,
They obtained a person who had placed the ad?
correct.
Or is it the words by any other means? By
They
any
obtained
means.
the person. I believe they obtained the person. The any other means is it's not, if you, it's purposefully broad to encompass, and I think the McGee language is this, the knowingly undertaking specified activities that will enable or cause another person to engage in selling sexual services. So it is that responding to a back page ad, that negotiation, which is causing, but for that activity right there, a person to engage in this act. And for that reason, I think under the plain statutory language, and both looking at Dabney and McGee, that there is probable cause to believe that they engaged in human trafficking. Now, turning to the second issue, that another person issue, I think that the judge made a clearly erroneous ruling in that respect based on the Bell case, which is from this court. In that case, though it is not a human trafficking case, it is a similar sting operation. The defendant was charged with attempted rape of a child and solicitation of sex for a fee. This was pre the human trafficking statute. Both of those charges employ another person language identical to the human trafficking language. And this court held that there does not need to be a real victim because factual impossibility is not a defense to a crime in the Commonwealth of Massachusetts.
Okay, so what do we do with Fan? Doesn't Fan suggest that there has to be a victim? I mean, doesn't Fan say that there has to be a victim? Just don't have to know their name. Isn't that basically the holding of the case?
I think Fan is talking about when you prosecute, and again, the human trafficking statute is very broad. When you prosecute, and you can, and this again is by design because it's to fill gaps which exist in the existing legislation. When a prosecution goes forward like it did in Fan under a theory that there's a continuing course of conduct, that is, the Fan case is speaking and the SJC is speaking to that specific type of prosecution of the case. I don't believe, and I think it would be not consistent with other law, which talks about factual impossibility, to hold that another person necessarily has to exist every time that this statute is employed.
Because, so the law of factual impossibility informs our construction of this statute? Or our reading of Fan?
Correct. In Fan, the argument was not that the argument was that there needed to be a named person. And I think it's interesting that SJC in Fan does talk about the different ways that this crime could be prosecuted. They said the Commonwealth could have named an individual victim and gone forward with, 27 counts of human trafficking as to that named victim. There's no dispute in that case that there actually was a victim. There's no dispute that there were brothels that were operating with actual people. So it just simply isn't the same type of factual scenario that's presented here. I don't think if you look at general factual impossibility as it exists across the law, but other similar statutes which employ similar another person language, which necessarily encompass the same sort of sting operation like Bell did. I think that interpreting this statute in conjunction with those statutes in the law of factual impossibility demonstrates that the judge committed a legal error. I have 1 minute and 6 seconds. I'm happy to answer any other questions the court has. Otherwise, I'll rest on my brief.
All right, thank you.
Thank you.
Whenever you're ready.
Good morning, Your Honors. My name is Patrick Noonan. I represent Brendan Garofalo, and I'll be delivering arguments on behalf of all other defendants, and I just want to recognize that there are co-counsels in the room as well. I just want to dive in by answering some of the issues or some of the questions that were raised. First, I would just contend that the motion judge got it right, and you should uphold his decision. But there were...
We have to decide that Bell is wrong?
Well, I think Bell is in a posit to the case because Bell was actually examining an attempt statute. They weren't...
Is this an attempt statute?
Well, attempt is actually within the sex trafficking statute, but in Bell, they were actually charged under the attempt statute. So it was...
Why is that a difference? I mean, this is an attempt statute. It criminalizes attempt.
So yes, so because attempt is within the body of the statute, and when Fan is actually analyzing the statute, they're examining the entire body of the statute, including the language about attempt, but also about the substantive offense and how you commit it. So I think when Justice Gaziano was looking at the whole statute, which includes attempt and the underlying offense, he's saying with attempt and the substantive offense, you need a human being and you need a victim. And Justice Englander, you had asked earlier, does Fan say you need a victim? And actually, it says directly that you need a victim. And Justice Gaziano had said...
What language are you relying on for that?
I'm sorry?
What language are you relying on for that
So,
proposition?
and actually, the motion judge quotes the language in FAM, which is to prove there was a victim, someone whom the defendant enabled or caused to engage in commercial sexual activity. So we're defining a person and another person as a human being, and Justice Gaziano was saying to prove there was a victim. So, and that is the intent of the whole statute to begin with, is to protect
To
actual.
prove there was a victim?
Yes. So in this case.
Where's that?
Yeah, where's that?
So if we
I'm trouble finding it.
if we go to, sorry.
I've underlined various parts of FAN,
Yes.
but I'm not finding that language.
I highlighted.
maybe,
Judge Ditkoff says he highlighted his.
I'm sorry. Did you?
Just
He's
kidding.
underlining. It's old school. I'm highlighting.
Okay. Well, I know it's in FAN, and I know that the motion judge quotes that particular portion, but I don't want to just kind of waste my, use up my time.
Well, I'm
kind of
not sure
going
you
in.
are wasting your time. I mean, I read the opinion for this kind of thing.
Yes.
So where does it tell me that there must be a known, not a known, but a victim, if you will? And
Yeah.
I had trouble finding it saying that. I mean, it was rejecting the notion, the argument made in FAN was you have to know who the victim is, and the court rejected that. Where does the court say, but there does have to be a victim? Of course,
Okay.
it's not dealing with an attempt, but I
It
understand
says,
the point you just
right,
made about that.
It says right here in FAN, quote, "Although the Commonwealth must prove beyond a reasonable doubt that there was a victim, i.e. someone whom the defendant enabled or caused to engage in commercial sexual activity, it need not prove the identity of the victim." So Justice Gaziano
That
is
is on
saying,
what page?
I think it's 9, but it's also quoted in, I think, Judge Kirpolani's decision. In this particular case, the Commonwealth doesn't have a human being or a named victim, and they acknowledge, even in their indictment itself, that they're alleging that the victim is society. So there's no human being, as Justice Kirpolani correctly found, but we're talking about a fictitious person, the person from the ad who's not a real human being.
But they attempted to have sexual relations with a person.
Well, what I would say that they did was they violated the sex for a fee statute. And
You didn't answer my question, because, yeah, okay, there's another statute that applies.
Yes.
Did they attempt to have sexual relations with a person?
yes, because they, in a conversation, they offered to pay or agreed to pay.
So why
Yeah.
doesn't that fall within the language of the statute?
Because I think when the FAN court was analyzing the entire sex trafficking statute, an attempt is in there, and they're saying that you need a human being, I think that they're not differentiating. In other words, in FAN, they're not parsing the statute out and separating, this is what you need for attempt, and this is what you need for the substantive offense. They're analyzing the whole statute. So I think it's I think it's incorporated into that. And just to address some of the other issues that were raised earlier, in terms of the legislative intent, it wasn't Deval Patrick who had made those comments regarding the legislative intent. The defense in the motion to dismiss in the underlying court, we actually included the Associated Press article because in Dabney, they quote an Associated Press article about the legislative intent. And we attached that article, and it's in the record. And it's actually Martha Coakley who was giving her commentary on what the sex trafficking statute means.
So the SJC got it wrong in Dabney as to who they attributed the language to?
Yes, because they quote the Associated Press article, and they quote that language, changing the focus to going after those who pay for
So is
sex.
it binding precedent now that Deval Patrick said that?
Well, they're quoting the Associated Press article, and nowhere in that article is Deval Patrick quoted. It's Martha Coakley who's making the comment. And then in the FAN decision, Justice Gaziano refers to that Associated Press article, and he omits that language about changing the focus to going after those who pay for sex. And then when Judge Kirpalani looks at the legislative intent, he also omits that language about going after those who pay for sex. So in the Commonwealth's brief, I don't really see any clear legislative authority that they're looking at to see that this was a statute that was designed or intended to go after those who pay for sex. And I believe that Justice Engler made a good point. When you think of these type of cases, you think of those who are making money off of this. And I cite
value.
Yes. Well, I cite
Other than sexual relations with that person.
But that's certainly not required under the statute. If you were helping other people to engage in prostitution because you just liked prostitution, you would still be violating the statute.
Right.
Even though that's not the heartland of the case, of the statute.
Exactly. And when we had cited some of the legislative intent behind the statute, it was, one of the reasons was to go after pimps and those who are trafficking and those that are, profiting and financial gain and things of that nature. And we had cited some of that.
The statute is broader than that, right? Why don't we turn to that for a moment, if you will? I gather that in the lower court, although the judge did not ground his decision on this, you argued that the behavior that was established before the grand jury did not fall within the language of the statute for another reason, not just the no victim reason, but also just doesn't fall within the language of the statute.
Yes, and we were talking about enticement earlier, and I recall the Commonwealth versus Hall case, which is a child enticement case, which talked about enticement as to enticing somebody to a particular location, and we were talking earlier about the fact that the defendants didn't post the ad; they were responding to it. They're not the ones that chose the location.
What do you do with Ms. Campbell's? I'm going to get the name wrong. Yeah, I guess it's Kaylin.
Yes, ADA Campbell.
Sorry, almost, senior moment. Anyway, what do you do with her argument, though, that says, look, then they engage in a back and forth. So they respond to an ad, but they engage in a back and forth. Part of the back and forth is to identify a place. Does that qualify, or is that sufficient for probable cause, that that's enticement or obtaining by any means sexual relations?
Well, I would say it's certainly not enticement if we look at Commonwealth versus Hall, because the defendants are not the ones that are luring anybody to a particular location that they chose. That's what enticement under that case means. The defendant is choosing the location to entice the person to, but I guess under any means that could mean anything. So I have a hard argument on what any means. But
well, it has to be obtained by any means. Obtain.
Yes, and I think in the jury instructions they actually define obtain as to acquire or to get. So they're not in the conversation. They're not acquiring anybody. They're not getting anybody. They're having a dialogue, and the officers are the ones that are choosing the location to go to. But I think that it's clear that the very simple, straightforward issue before Justice Kirpalani and upon review is that language in Fan. And the Commonwealth alleging that the victim in this case is society, and the fact that we don't have another person or another human being who would be caused or enabled to engage in commercial sexual activity, because we don't have a victim. We have an officer, and we have who's posing as a fictitious person.
Under that thinking, it strikes me that you're arguing for a construction or a reading of Fan that's inconsistent with Bell.
Yes, well, why do you think Bell's talking about factual possibility, which is this whole separate thing, but I think what Fan is doing...
But is it? I mean, isn't that really what we got to grapple with? Is it really a quote-unquote whole separate thing? I mean, Fan didn't talk about attempt.
But I think what Bell's talking about factual possibility, but I think what Fan is doing, they're just simply defining an element of the offense, that you need an actual person and you need a victim. And then Justice Kirpalani is just looking at the facts and he's saying, there's no person, there's no human being, there's no victim. I think it's just an application of an element of the offense that the SJC has just defined. And
don't we have to find that the SJC sub rosa struck down the attempt part of the statute in Fan to get there? I mean, wouldn't the attempt never work in that situation?
Well, I just think that, I mean, the fan case was one of those where we really needed to take a look at this statute and analyze it. And I think this was the SJC's opportunity to sink its teeth into it and attempt is within the body of the statute. And, you know, Justice Gaziano is defining terms. And I think if there was some ambiguity about attempt, I think he would have addressed it. But I
don't
think
understand why there wouldn't be, why it wouldn't satisfy attempt if there was an actual human being at the other end of this. So if somebody responded to an ad and spoke to somebody, and then, I don't know, for some reason it doesn't get, the transaction doesn't occur. They don't, you know, they don't both show up at the same place. They get confused. I don't know.
But I think that use of attempt would just be completely contradictory to what we have this extra fee statute for, which
in your brief you argue about that, right? I guess my question is that although it's not a related statute, for example, child pornography, right? An undercover officer pretends to be an 8 or a 10-year-old, and the person on the other side of the screen is typing away, believing that he or she is engaging with an 8 or 10-year-old. How is that any different in that analysis of?
Right. And what I would say is, you know, the purpose of those statutes is obviously to protect children, but in the child enticement statute, they say that somebody needs to entice a child under the age of 16 or someone whom he believed to be a child under the age of 16. So that's where we get into that sort of territory. And if we're talking about, you know, whether the Commonwealth has to prove whether it's a actual prostitute or an officer posing as a prostitute, I think that the legislature could have just simply clarified that quite easily by saying person, and then clarifying it by saying for somebody whom the defendant believed would engage in commercial sexual activity. And I think that would have addressed a lot of the issues here. But I'm running out of time. I have about a minute, but if...
Take that hypothetical a little bit for me. So a real person, a 13-year-old, puts something out on the internet suggesting that they are interested in sexual relations. There is someone who becomes a defendant who responds to that. Enticement? They say, hey, let's get together. Enticement?
Is the defendant saying let's get together, or is the...
Well, the defendant is responding to something that the 13-year-old has put over the wire.
Well, in the child enticement statute, they have entice as one of the means, but I think they have other sort of things like lure.
But is that, I mean, we're trying to, one thing we may need to do, maybe. So it wasn't what the judge decided below, and I have to look at what was argued, but is try to define the word entice. So I'm trying to get at that with a slightly different hypothetical. Would that satisfy enticement? The 13-year-old puts out, I'm interested. Someone responds and starts a conversation about, yeah, so am I. I'd like to meet with you.
Well, I think under Commonwealth versus Hall that it would not be, because it's the defendant is not luring or enticing the child to a particular location chosen by the defendant. That's under Hall. That's the definition of enticement, and I think maybe we would have to look at Hall and see if it applies here. But I just wanted to say one thing. When we're looking at this motion to dismiss, what was argued and focused on below was the fan decision and human being and victim, and how, and under these circumstances, that was not proven that there was a victim or a human being. So I think that's the crux of the entire case. But I understand there was other issues, but that's the meat of it. And I thank you for your time.
Counsel, you remain privately retained just for the fees?
Yes. So there are two of the attorneys are private, and the other attorneys are appointed.
All right. Well, thank you both. This is actually a pretty interesting case, and it was well briefed and well argued. Thank you.
Thank you very much.
Whatever you'd like to do.
Sure, that's fine.
All right. We'll take one more case before our break. I'll call 23P 236, GALLOTTA versus Burns. Whenever you're ready.
Good morning. May it please the court, my name is William Rose, and I represent the appellant Jeffrey Burns and the appellee Marsha Burns. Just as and with me is Christopher O'Rourke, who is trial counsel. Since I represent both an appellant and an appellee, I was just wondering procedurally how you want to proceed. Should I?
This is your argument. You argue everything in this 15 minutes, however you want to do it. Okay,
thank you. Basically, there's 4 issues in the case, 3 that we raised and 1 that was raised by my brother. The first one is the introduction and the treatment of the alcohol consumption by the 2 drivers in this accident. First of all, this is a negligence case, duty, breach, causation, and damages. The defendant admitted to crossing the center line, admitted to causing the accident, or being a substantial contributing cause of the accident.
Did you concede negligence prior to trial?
It was not, but it was admitted in the opening statement. It was admitted in testimony.
But the defense chose to litigate the issue of whether or not Mr. Burns was negligent.
It's true, we did not.
It wasn't just a damages trial.
It was not, correct. Okay. But it was a straight negligence case of a driver crossing the road, the center line, and hitting oncoming traffic. You don't need the why to explain why that happened, to find him negligent. The jury was asked to find negligence, and...
Had you conceded there wouldn't be a contributory infringement defense?
Contributory infringement?
Negligence.
I'm sorry.
Contributory negligence.
I was a patent lawyer, and I just had another senior moment. Had you conceded there wasn't going to be a contrib defense?
No, that issue was raised, and that's why the testimony about the 2 Mai Tais that Mr. GALLOTTA had became relevant or became an issue. And basically, there's 2 arguments as to why we contest that.
Well, if you're going to argue contrib and you've left it in the case, how is it that the plaintiff can be prevented from putting in the evidence of drinking?
Well, we actually reserved at the beginning of the trial, and then when the evidence came in about alcohol.
Reserved whether or not you were going to make a contributory negligence defense.
Correct.
I mean, isn't
there was a motion in limine.
Isn't that the problem? You ask for a verdict slip that's going to ask whether the defendant was negligent, then that lets the plaintiff prove the defendant was negligent. They don't just get to prove it a little. They get to prove as much as they can.
But it already was negligence. There was no need.
You didn't concede it, so you can't tell the plaintiff how to try their case, right?
Correct.
And do you have any case law to suggest? I didn't see any. And independent research, while limited, I did not find one case to support your principle that it was error for the judge to allow the admission of alcohol consumption.
We're relying on Rule 403. Probative value versus prejudice to the defendant. And also 403 talks about confusion, adding issues to the trial that are not necessary. The whole issue of impairment, whether Mr. Burns was impaired or not, that was unnecessary to prove his negligence. It became the central issue in the case. When Mr. O'Rourke argued the motion in limine before the trial, he said this would be inflammatory, it would turn it into a drunk driving case. The judge agreed, said it likely is inflammatory, and it could convert this into a drunk driving case when it was just a straight negligence case. And then the next day, he found that it was central to the plaintiff's case. It wasn't. The issue was negligence, and basically we conceded negligence. We didn't concede it, formally, but we basically admitted it. And so it was unnecessary to prove the issue in the case that mattered. So it had very little probative value, but it was very prejudicial to Mr. Burns. The case was tried as a drunk driving case. Plaintiff's opening, plaintiff's closing, plaintiff's first witness. It was all about alcohol consumption when he only had 2 or 3 beers.
That's quite a bit of an exaggeration. There were maybe 4 pages in Officer Cole's testimony about intoxication. Wasn't the entirety of it. Wouldn't you agree with that?
I do not. On redirect, it was brought up to the point where he got to testify that he thought that Mr. Burns wasn't telling the truth and actually had more than he claimed he had. So he not only suggested he had more beers than he said, but he questioned his credibility.
You'd agree with me that in a criminal case for negligent operation, the Commonwealth is entitled to prove evidence of alcohol consumption, to introduce evidence of alcohol consumption, correct?
In what type of case?
In a criminal prosecution for negligent operation of a motor vehicle.
Right.
Case law is clear that the Commonwealth is entitled to produce evidence, if they have it, that the driver, the defendant, had been consuming alcohol.
Okay.
Right?
Yeah,
You
Mr. Burns
agree?
was charged with OUI.
So you agree, in a criminal context, it's admissible. It's damaging. Most evidence is against the defendant, right?
Right.
So in a civil action, you want a different rule that doesn't exist yet, by case law or by statute. You're saying that the judge erred when doing just the typical probative value and prejudice.
Correct.
You say that was an abuse of discretion.
Correct. Because the probative value, the case was unnecessary to prove negligence, and it was very harmful and very prejudicial
Oh, it was
to the
harmful,
defendant.
but are you still going forward with your 23179G argument?
Yes, I am. Can I make one other point about the alcohol? Mr. GALLOTTA had 2 Mai Tais in basically the same time frame that Mr. Burns had his beers. My brother argued that there was no evidence that Mr. GALLOTTA was impaired or that had any impact on the accident. That's exactly our argument.
Well, I don't understand why that matters. I don't see an issue on appeal where you're saying the judge erred by not allowing the contributory negligence argument to be made, right?
I would refer you to volume 4, page 39. The judge said that there was not enough evidence that 2 drinks would support a comparative negligence claim.
He said that, but I don't have an issue on appeal, right? You're not saying this case should be retried because we weren't allowed to present a contributory negligence argument.
No, my argument is
Any
that
event
we were treated completely different.
Because the evidence is different. Against your client, there's evidence that his eyes are bloodshot and glassy, that he was thick-tongued and slurring his speech, that he was leaning on the trash cans on the sidewalk, he was leaning on that to balance, and that he certainly had to have had more than 2 drinks. And there wasn't any of that evidence against the plaintiffs, right?
Correct. First of all, that was Officer Cole, and when he first showed up, there was an airbag that he saw the airbag had been deployed, and he knew from seeing him that Mr. Burns had a head injury.
But this issue isn't properly before us. Would you agree?
Why?
The contrib issue
I
is
agree.
not before us.
I agree.
You're just saying they were treated differently.
Yeah,
I'm not
on
saying-
the alcohol issue, it's probe of value and prejudice, not my guy got treated worse than the other guy.
No, that's, my argument is what you just said.
Well, that's not the argument before us, and there's no rule of law.
No, the parties have to be treated the same. You can't have one standard for the
Even if the
defendant,
evidence
one
is
for the
different?
plaintiff.
They have to treat the same even if the evidence is substantially different?
How is it substantially different? It was the
Because
same.
one of the people is leaning on a trash can to balance his slurred speech, bloodshot eyes, and the other one doesn't have any of that.
First of all, there's no evidence of any, why didn't he do a field sobriety test? He was with Mr. Burns for 10 or 15 minutes, according to his testimony. Never did a field sobriety test. There's no blood alcohol. There's no expert. There's no testimony on causation. You know,
Because he
it's
doesn't need to.
speculative.
It's simply putting in evidence of what he observed and whether it's relevant to a negligence claim. Why wouldn't the evidence be relevant to the claim against Mrs. Burns? The evidence of alcohol consumption by her husband, is it relevant to the claim against Mrs. Burns?
She wasn't home. She didn't know what his activities were that day.
Was that
Yeah.
something that had to be accepted as a matter of law?
What? That she didn't know?
Yeah.
Yes, the statute, well, the Picard case says that,
Be accepted as a matter of law, that there was, and therefore was irrelevant to the claim against Mrs. Burns. Is that your argument?
no, my argument is the Picard case says that negligent entrustment is determined by the person's knowledge at the time of the entrusting. So presumably the entrustment happened that day. She left for work at like 8 in the morning and was still at work at 9 o'clock at night. So she didn't know what his activities were. She didn't know if he had had any beers or not. She had no knowledge of that. So there's no, and he had a clean drive.
Negligent entrustment was the claim was that for a significant period of time, the theory was he drank too much and he got behind the wheel of a car. And by the way, he was a lousy driver even if there's not evidence of alcohol, and she knew it. So then that evidence would be relevant, I would suggest.
The
Prejudicial,
evidence,
sure, but relevant to a jury determining, you know,
the evidence was that he had a clean driving record for 7 years prior to the accident. And then for the prior 19 years, he had a few property damage only claims. No drunk driving, no bodily injury claims, none of that. Those were 20 years before. So for 19 years, he didn't have a bodily injury claim or a drunk driving charge.
can you move to your 79G argument?
Yes. I would refer the court to 4 pages of the record.
Why doesn't it have to be attested to just at trial, like the case law seems to suggest?
He's right. That's right.
Okay.
The bills were offered, page 7 of volume 3. That's when they were first offered. They were offered as undisputed. My brother, Mr. O'Rourke, objected at page 20 of volume 3. The plaintiff's counsel said he was unaware of the issue, so he hadn't had a certification as of then. If you look at the first page of volume 3, it's dated September 8th, 2022. If you look at the certification, which is volume 8, page 15, it's the same day, September 8th, 2022.
I don't understand the argument yet. That your opponent says this, all that needed to happen was that it was attested to at the time of trial and that it was attested to at the time of trial. Are you saying it was not?
It was not.
How do we know that?
Because of volume 8, page 15. It was dated the day of the objection. So the objection was made, the certification was obtained later, and then it was submitted the next day. That's not fair to the defendant.
Why?
Makes the objection.
Why isn't that fair? Why isn't that fair?
Why isn't it fair?
Yeah.
Because what's the defendant supposed to do? If he doesn't object, the records come in as undisputed. If he objects and the plaintiff
He's
corrects...
supposed to either accept the records and argue his case or find a witness to contest the records in some way. And he had plenty of notice that the records were going in because the statute requires that, and it happened. That's what he's supposed to do.
The Grant versus Lewis Boyle case says if you don't have the certification, they don't come in. They're hearsay.
And they have the certification before they came in.
They
I'm looking at them here in the record, and they've got a certification on them.
not when they were first offered.
But when they came in,
Well, that's the issue. If you find that that's okay, then I lose. I agree. But they were not certified when they were first offered, and that puts the defendant in a no-win situation.
I don't understand. If a defendant makes an objection and say no foundation, is it unfair for the other side to then lay the foundation?
No, you can.
Okay, so that's what happened here. There's no foundation, it's not properly certified. The plaintiff then decides to get it properly certified, just like if you say objection, no foundation, then they lay the foundation. What's the problem?
No, it's not no foundation, it's hearsay. It's inadmissible hearsay evidence. And so they
Let's try it that way. You object on the grounds of hearsay, and then the other side brings in a precipient witness. Is that not allowed?
That is, but that's totally unfair to the defendant. What's he supposed to do? And if I could, a major issue in this case is the plaintiff's testifying to totally undocumented medical conditions.
Okay,
totally
it looked
changes the
like
case.
every citation you had on there, except for one, it looked like it was evidence that you had elicited. As far as I could tell. I looked at all the citations you gave, and it was all Alan's cross, Diane's cross, except for one thing on redirect of Diane that wasn't objected to. Am I wrong on that?
I don't know specifically, to be honest with you. I don't think that's right. I mean, she
Well,
testified.
let me try to relate. Did you object to any of this?
Yes.
Because I didn't see that either.
The objection was made, Volume 3, page 16. There was no medical support regarding, it came up in the context of the issue of permanent impairment or permanent injury. And Mr. O'Rourke objected on the grounds that there was no medical evidence. The judge said, all right, we'll let the evidence come in. And what does that mean? There's no medical evidence at all. The only testimony was going to be from the plaintiffs themselves. And they testified that, for example, Mrs. Gallotta testified that she was taking medications forever. I'm pretty sure she said that on direct. She said she was still treating. She said she had a stroke and an aneurysm. None of that.
She said she had a stroke and an aneurysm. I think that is in her direct. Did anybody object to that?
No, but the judge had already determined that it was admissible, that he was overruling the objection.
He overruled an objection based on whether she had permanent injury, not on whether she had an aneurysm.
But it's the same issue. It's all about medical treatment and medical conditions.
I wouldn't have thought so.
But what about her range of motion testimony? 60%
So
on
wait,
one
wait,
side,
so
75%
wait,
on the other. That's an expert witness.
316 was what your objection was? If there's no medical evidence of any permanent injuries, I don't know why the jury would have to consider her life expectancy. So your objection, I understand you objected to those life expectancy tables. Sorry, it took me a little while to find it. I've kind of weirdly did my iPad.
The objection was, I mean, he said it multiple times, no medical support for permanency, so there was no reason for the life tables to come in. So the issue was...
Yeah, but that's an objection to the life tables. It's not an objection to the evidence he then elicits in cross, or even that gets elicited by the other side.
That's later on. That's after the judge has decided he's going to let the plaintiffs testify about the symptoms and conditions. And, you know,
Don't see that.
I'm sorry?
I don't see the judge saying, I'm going to let the plaintiffs testify about their medical conditions. I don't see that ruling.
How about page 19, volume 3? He said he wanted to see the evidence. There's no medical
Right,
records.
so I invite you to renew your argument. So that sounds like it's not a ruling, that he's asking, the judge is asking for objections at the time, which don't happen.
Right, but what evidence is going to come in that changes it? The argument
Changes,
is
I want to see the evidence. We'll see what the evidence actually does show, and I invite you, Mr. O'Rourke, to renew your argument. Seems like at that point you'd have to object, since the judge said he wanted to see what it was and then hear from you again.
But what changed?
Not you again, but...
What changed? The argument is you can't testify...
What changed, the evidence came in that he wanted to see before he made a ruling. He actually heard the questions.
But the issue was, there's no medical report to substantiate certain conditions. And the judge said, we'll let them testify.
Where did the judge say that? I didn't see that.
Page 19, he said, I want to see the evidence come in.
Yeah, that's not the same thing as we'll let them testify.
What's different?
What's different? Okay,
There's no other evidence that's coming in other than their testimony. There's no medical records. So the only thing coming in is their testimony. So he's already allowed it.
All right.
Thank you.
Thank you, counsel.
Good morning, Justices. I'm Robert Berluti, representing the Gallottas. With respect to some of the questions about the alcohol, the admission of the alcohol consumption, I submit Your Honors have it right, and we've briefed it extensively. This was a civil case. The standard for...
Don't assume you know what we think based on what we asked.
Understood. But the point is that it's a negligence claim, and you can find negligence for operation and anything, from the weather, the road conditions, and everything else. And the case
If they had conceded negligence,
Excuse me?
you couldn't have put it in, right?
If they had what?
If they had conceded the negligence of Mr. Burns, you
If-
could not
if
have
they
put
had
the evidence in.
If they had conceded it, I agree, would be a much closer question. I agree with that.
So you want a new trial, a portion of a
Not
new
entirely,
trial
just as against Mrs. Burns.
on the negligent entrustment.
Right, yes.
And I read your brief to say, without any exception, without any limitation, basically the whole registry of motor vehicle documents should have come in.
That's right.
Do you have any case law to support that, first
Well,
of all?
the cases that we found were cited, Judge, and that the first one was
No, for your proposition that anytime, any place, anywhere, you've got anything on your registry of motor vehicles,
He's 16 years old.
and now you're 80,
So-
and, yep, so do
I-
you have a case that says that proposition?
It's a tag team here.
Understood, understood. I would point to the statute itself, the Chapter 90, Section 24, to this extent. Somebody gets convicted at age 20 of an OUI. They then get convicted at age 40 of an OUI. They then get convicted at age 60 of an OUI. The conviction at age 60 becomes a third offense. There's no
Yeah, but
time on it.
that's
But
because
the
of
jury-
Chapter 90, 24, and the specific ways in which the Commonwealth can prove it's set out by statute. In this particular instance, maybe you could make an argument to a judge that, hey, every 20 years, Judge, this individual gets convicted of drunk driving, and I want to bring that to the jury's attention. What your argument is that the judge can't even weigh probative value and prejudice and come up with a decision. So in your instance, I looked at it and I thought, if you're 80 years old and at 16, you fail to stop for a school bus, it automatically comes in under your theory without any support in the law, that we can't do a probative value and prejudice analysis.
The judge, in his instruction, added a gloss of the recent past, and I cited to it in my...
Yeah, but that
in
was
my
just to make sure he was being accurate factually.
Well, because of what he let in. But notwithstanding...
Because of what he decided to let in.
Right.
What's their standard of review? It's the evidence you're trying to put in is evidence of other acts of the defendant, right?
Not
It
as to the
occurred 20 years ago.
not as to the defendant, not as to the defendant driver, as to his wife on negligent
Either
entrustment.
way, it doesn't matter. Maybe, yeah, you're trying to put in, okay, it's even worse. You're not even trying to put in other acts evidence of the defendant. You're trying to put in other acts evidence of someone else. But isn't that subject to an abuse of discretion standard of review here?
I think it's whether or not it's harmless error. Yeah, I do think it's an abuse of discretion. I think he did abuse his discretion. I don't think that for purposes of negligent entrustment and what Marcia Burns knew, I should have been able to ask her those questions and ask her if she even considered that, and that the jury could have considered it. To respond to you, Justice Walsh, I think it's ripe for argument. What weight should have been given, not to admissibility, that it does come in, and that then the person could argue that the jury should give very little weight to that. And if it was as extreme as you say, I suspect reasonable
But,
jurors would have given very
I
little
think
weight.
for centuries, courts have been excluding other act evidence. For centuries. And that's all this is. It's things he did, and it happens to be over 20 years ago. And the court decides, you know what? And I also get Rule 403, so I get to decide whether it's more prejudicial than probative. It's subject to an abuse of discretion standard review,
Well,
which means it has to be outside the range of reasonable alternatives that the judge had available.
and I think it was, Judge, for this reason. What he did in this case is exactly what he did earlier on. It's exactly what he did earlier on. He drank and drove, he drove poorly, he caused an accident, and he caused serious bodily injury. So I don't think that it was something totally different.
If this was a singular issue just about negligent entrustment, right? I think your argument would have some force, but it wasn't. It was a trial about the whole. And so the judge, the trial judge is sitting there determining whether the prejudice to both parties would be outweighed by its value. And the fact that he got charged with, or his license was suspended for drunk driving at least 3 times, you're saying it's an abuse of discretion to say it's prejudicial to the point where it outweighs its value?
I think it's very probative, Judge, so I do. I think it's more probative than it is prejudicial. All of this is prejudicial. That's the whole point. That's why we offer it. It's very prejudicial, but it's also very probative. And it's very probative as to her knowledge. This was not what he let in, and certainly what was argued extensively by defense counsel was, oh, look, he's got a couple of, motor vehicle citations, and he's got a couple of accidents that weren't even serious accidents, et cetera. It distorted the entire record. And it did not give the jurors a fair look at what kind of driver this is. Most importantly, on the roads of the Commonwealth, Mr. Burns is out there still driving. And, Mrs. Burns made a calculation, and my clients ended up...
That was a matter of the... Well, that was not why you were in front of the jury, and you were not allowed to argue that to the jury. That was the matter for the criminal courts, and he was found not guilty of operating under the influence, right?
That's right.
Okay. So let me ask you a question. Do you think that so your client, Mrs. GALLOTTA, testified that she had an aneurysm,
right,
and headaches, right?
Right.
And there was no medical testimony with respect to whether that could have been connected to the crash, right?
Temporally, it occurred within 10 days to 2 weeks. They were in the very same medical rate. It happened within 2 weeks.
And that's enough in your view? You don't need an expert. Was it objected to?
It was not objected to. It was not objected to. She testified as to what was going on. She testified as to the impact. She had permanent disfigurement. That's one of the reasons for the life expectancy tables. But that aside, she was suffering from headaches so badly that she had to go back in to the hospital. And in fact, she did have an aneurysm. And I think it's within fair game for the jurors to say, look, never had any symptoms with respect to the aneurysm. She gets into this substantial car accident.
Did she testify never had any symptoms before?
She did.
You put that evidence in?
Very well could have, Judge. I don't recall.
I'm asking. It was a question.
I think I did, yeah.
And you think
she was
that if
cross-examined
someone had
on
moved in limine in advance and said, you know what, can't put that in without a doc. We need a doc to tie the aneurysm to the crash. That should still have been allowed simply because it was temporarily, in your view, temporally related.
The answer to that is yes, but I also think that notwithstanding the evidence of the aneurysm didn't substantially affect what the jury awarded with respect to damages. She had permanent disfigurement. She had very significant bruising. She had to wear the J collar for 3 months. This was not a runaway jury. I think the amounts awarded were well within reason given the evidence before it and given the evidence that they testified about. I would just like to go back for 1 second and commend to the court, again, it's cited, to the case of Mitchell versus Hastings and Koch Enterprises, 38 Mass App Court 271, in which the decision says, Nowak's driving record showed many violations, including 3 convictions of driving under the influence of alcoholic beverages, and the jury could properly conclude from his record that he was an unfit driver. There is nothing in that decision about temporal connection of when those OUIs occurred. They're a part of his record. And therefore, it's evidence, and it's competent evidence for the jury to assess as to whether or not he was a fit driver. That was our responsibility. How else can you prove it? but through his driving
Could have
record.
proved it with the fact that he had an OUI within the last 7 years, or even the last 20, according to what the judge did. But he hadn't. He hadn't. The evidence was that he hadn't had an OUI in 20 years.
Well, he had, in part because his license had been
And, you know,
suspended for part of
I
that.
saw in your brief, but we have a limit, for example, on prior criminal activity and what we'll allow in. It's 11 years.
I understand that, and I agree with that. And if it was offered as against Mr. Burns, I think that argument has much more sway than when it's strictly for prior bad acts. This goes to the knowledge of Mrs. Burns as to whether or not he's a fit driver. The conduct he engaged in that night was the exact same conduct that he had a history of engaging in. Maybe not recent in the past, 10 or 15 or 20 years, but nonetheless, he went back to it. And by the way, what we don't know is that maybe he just didn't get caught over the last 10 or 15 or 20 years. We don't know that. We also have that with respect to something earlier about her knowledge, the evidence was, at the time of the incident, the first thing Mr. Burns said to the police officer, Officer Cole, as well as to Alan GALLOTTA and to the passenger in that car, one of the passengers, was that he was on the phone with his wife arguing. And that's what caused him to swerve into the other lane. So there was, I submit, there was circumstantial evidence that
That she knew.
that she knew.
Of course, he was already on the road by that point.
Well, he was, but maybe that's what they were arguing about. And it just,
The jury heard that evidence and ruled against you.
the jury heard his inconsistent statements. At trial, Mr. Burns denied that that was accurate. Didn't deny saying it, but denied that it was accurate. Claimed at trial that he dropped his cell phone, bent over to pick it up, and that's what caused him to swerve. Are there any questions? I'm happy, the issue about the medical records, I think, is beyond the pale. The attestation existed at the time. If we had chosen to bring in a live witness to authenticate, that's all we're talking about, is authenticating the records they had, the bills they had. There was a question about wasn't given a field sobriety test. That isn't true. Officer Cole began to give him a field sobriety test and had him blowing into one of the portable things. The thing is, Officer Cole first asked,
Is this in our record?
Oh, it is. Officer Cole's testimony is, and that's what Officer Cole testified to. He then said, I want to go to he was offered first if he wanted to go to the doctors. He said no, to the hospital. He then, after they began, said he would go to the hospital, and that's when everything ended, and he went to the hospital. Then it was the defendant that offered the defendant's medical records from the Quincy Hospital and argued that when he was discharged over the hospital's recommendation, that the defendant's medical records said he was clinically sober, whatever that means. I'm not sure what that means, but he said he was clinically sober.
Where did Officer Cole testify about offering a breathalyzer? I didn't see that.
I thought that's what he did. What we didn't get in was his medical, was his police report, but he testified. I'd have to go back to it. But he testified as to all of the other things. But the thing with respect to whether his blood alcohol concentration, Mr. Burns went to the hospital and then left over the hospital's objection before he could be given a blood test. So he was a very sophisticated.
And that's in the record?
Yes, his medical records are in the record. Yes, that's one of the exhibits.
It says left before he could give a blood test?
Oh, yes, it's clear. He was never given a blood test.
But does it say that he left before he was given a blood test?
Yes. Yes, his medical records do.
Okay.
Any other questions? I thank the court. I would ask that the judgment as to Mr. Burns be affirmed and that a new trial as to liability on Mrs. Burns be ordered for the reasons set forth in the brief. Thank you.
All right, thank you both. We're going to take our break. It really will be no more than 15 minutes, so don't go too far.
And perhaps less.
Perhaps less.
All rise, please. Court is in recess.
All right, still morning. I'll call the fifth case, number 22P377, WATERMARK II Member LLC versus Kim. Counselor, whenever you're ready.
Your Honor, I think it is still morning, so I will wish you
Still
good
morning.
May it please the court. I am Ian Stone. I represent Justin Huang and Stella Kim, the appellants in this case. I believe, Your Honor, that I only have 3 or 4 essential sentences to say in support of each of the 3 arguments that are contained in the defendant's brief. Maybe
3 or 4 each, or 3 or 4 total?
3 or 4 per argument,
Okay.
Your Honors. The shortest number, I believe, concerns the revisions to, quote, correct the ledger of rents and payments. And the most important of the sentences to express, I think, concerning this issue is contained in the plaintiff appellee's brief at page 13. There, the appellee says of these corrections, in preparation for trial, appellee's attorney simply advised appellee to revise the ledger in 2 ways so that it shows the correct amount of rent due in accordance with the lease.
How were you prejudiced? Sorry, I may have cut in before your 4 sentences, although I think you were right at the outside of them.
Well, I wanted to point out, Your Honor, that corrections made in preparation for trial are not.
How were you prejudiced? How was your client prejudiced?
Well,
by the introduction of the ledger under circumstances where the only damages awarded were straight out of the lease in terms of the number of months that had been unpaid and what the rent was on the lease?
Your Honor, the defendants were plainly prejudiced from the corrections to the ledger, and the reason for this is because if these hearsay corrections had not been added, this inadmissible evidence of the numbers that come directly from the lease, if they had not come in, then the ledger would have controlled the damages part of the judgment. The lease would not have. The ledger, the demands for sums of money, Your Honors, would have been different. A different number, a different judgment.
How much different?
Thousands of dollars, Your Honor.
That's a related question. Are you challenging the judgment for possession?
Yes, Your Honor.
On what ground?
On the grounds that the defendant, Kim, requested to make her case to a jury, and this...
But why wouldn't a judge have had to direct out, at least as to possession, the number of damage? The damage is a number, obviously. This is a jury issue here in this case. Well, maybe that's not obvious, but may have been. But since she conceded that she didn't pay even the rent for the period before the lease jacks up, how could what defense was there to possess? Why wouldn't it be just directed out?
Well, Your Honor,
on possession.
with regard to the harm of preventing the jury trial, I think it is necessary to consider everything that a jury might have done and was authorized to do at that trial in relation to the counterclaims. For example, if the court is going to review the harm of the error of Kim not being able to make her case to a jury, the jury would have been authorized to send a question to the court. Can we award damages on the basis of these counterclaims? Can we...
But how would those have not have been directed out?
The jury would have had Kim's counterclaims before them, and they wouldn't have been directed out.
I didn't see any evidence of them.
Well, Kim's testimony was evidence.
But where in Kim's testimony is there enough evidence for a counterclaim or to defeat possession?
Your Honor, Kim made her case in her complaint concerning the sufferings that she had undergone, and in reviewing whether this would have made a difference, whether it could possibly have made a difference that Kim made this case to a jury rather than a judge, Your Honor, and weighing the harm of that error, I believe that that error affects the entire judgment for possession and for damages simply because, not because it might be said that, well, a jury would have done the same thing and the judge can see that the jury would have done the same thing. That conclusion on review isn't one that...
No, I get that, but if it never would have gotten to a jury, because it would have been directed out, then it really doesn't matter whether there was a jury there or not. So I'm asking you to convince me that there was enough evidence to get to the jury on possession or on any of the counterclaims at the trial, because I'm not seeing, now, on the damages, that's different, but on those two things.
In support of the claims getting to the jury, it seems that they would have. The claims wouldn't have been directed out because Kim's testimony would have supported her counterclaims.
Okay, what testimony was that? I didn't really see anything that supported a counterclaim. Could you give me a cite?
She was testifying to unsafe conditions. She was testifying to...
Where is that?
Okay. In her transcript at trial where she testified, and I cannot direct you to a page in the transcript where she raises this issue, I can say only generally that she was complaining that there were drug addicts, that everybody had left the apartment complex during COVID, that she was alone, that the mold, she was permitted to testify that the mold was black. This was something that there was an objection to, and that she was permitted to proceed with that statement. So it may well be that the jury would have been unmoved, but it is impossible to say what a jury would have done in circumstance with that. Jurors may have had their own experiences with black mold and may have concluded that in any event, Your Honor, simply reviewing for harm the denial of a procedure that is described in the Massachusetts Constitution as a right.
Well, your brother says that you didn't ask for a jury until 21 days after it needed to be elected under the rules. Is that right?
No, Your Honor. Ms. Kim submitted her request for a jury trial 2 days after the mediation event. The plaintiff emphatically states that no, the request for jury was made February 23rd. If you go to Record Appendix 1 at page 20, there is the court date stamp on the face of the motion that says February 12th, 10:42 a.m. That was when the request was made. Not particularly late, it had only become late.
It was late. It was 5 days late under those circumstances.
It was 5 days late, Your Honor, because the mediation, which the parties expected to be continued because the limited assistance representative said that he was not prepared, nevertheless occurred. Had it not occurred, had it occurred the following week,
because the rule says that the answer is due 3 days before the mediation?
3 days before the mediation is scheduled. I believe is the language, 3 days before the mediation is scheduled. So if it had been rescheduled, it would have been scheduled in the future, and the request for a jury then would be timely. Your Honor, the error here is that when a party makes such a request for a jury, since it is a constitutional right and rules explicitly that standing orders and summary process rules, was, quote, the rules do not allow the judge to set a late jury. But the rules do not prevent, because the Constitution requires a constitutional analysis as to whether the right remains And if it doesn't remain,
It's not unconstitutional to require a jury to be elected by a particular time, and if the jury's not elected, to determine that it's waived. That's not unconstitutional. Cases say that, right?
it's not unconstitutional in every circumstance, but it may be constitutional, Your Honor, in some circumstances.
What case says that?
Your Honor, any time that a rule... Your Honor,
What case says
I don't have a
that?
case for the proposition that says that when a party requests a procedure that is described in the Massachusetts Constitution as a right, that a constitutional analysis is necessary rather than a ruling that the standing orders and the court rules prevent that, that court from allowing that right.
Well, you said in... Go ahead.
Did anyone argue below to the judge that these summary process rules are unconstitutional?
Attorney Galasso, at the on March 9th, remarked on the right to a jury as a constitutional right, that the request was made only a few days late, that Ms. Kim should receive consideration from the court because of these reasons, and Attorney Galasso was correct. This is so. Ms. Kim was entitled to a constitutional analysis in her case as to whether or not...
It seems like you're asking us to hold that the summary process rules are unconstitutional. Is that, you didn't say in your brief.
No, Your Honor. My position on behalf of Ms. Kim is that when somebody requests a jury trial, it is necessary to do more than refer to the rules and the deadlines in the rules. It is rather necessary to examine the substance of the right.
But if the rules prohibit that relief, then why do you need to go past the rules?
Well,
Unless they're unconstitutional.
Rule 39,
But
in order to
the civil
prevent-
rules only apply to the extent they don't conflict with the summary process rules, and Rule 8A sure seems to say that if you miss the deadline, you're out.
Your Honor, the Rule 39, I think, is operative, even where it may appear to conflict, because only due to Rule 39 are the rules that require the waiver of juries constitutional, because it permits a judge to revisit the issue in the court's discretion and examine the substance of the right, which it is essential not to get away from. I don't know whether
Can I switch? I need to switch gears because I think there is actually an issue that we haven't touched on yet, and that is Mr. Wong.
Yes.
I take it that Mr. Wong is not contesting the award of possession?
Mr. Huang contests the judgments against him and states that they are void.
Including the judgment of possession?
All judgments reached with respect to Judge
Then you have
Huang.
to, so I understood your argument with respect to Mr. Wang. Is it Wang?
Huang.
Wang. With respect to Mr. Wang, I understood your argument to be he wasn't served. Failure of service process. If the case is, I want possession under the lease, how can it not be effective service of process to serve him at the premises where he has the lease?
Because the action for possession is a court action, just like the part of the action for damages.
So if I can't find my tenant because he's chosen to leave, I can't get possession of the premises again because I can't find them, so I can't serve them?
No, Your Honor. You go through the process of making
Well, if they've left, I don't know where they are.
You make, one must make every diligent effort to provide service to apprise the party of the pending action. Now, if the party can't be reached, then what appears is a default judgment. Your Honor, I request a default judgment. Well,
No, you can't get a default judgment until you establish service of process. I understood your argument to be, hey, my person never received constitutional service of process. But now you tell me you're not waiving a defense to possession. And I say to myself, in a summary process case where I'm trying to get possession of a particular property, that your client now is still claiming he's entitled to possess, I can't serve him by leaving it at the premises?
Your Honor,
How can that be?
Mr. Huang hasn't asserted anything under the lease or at summary process trial or in the housing court or in the
Right,
appeals
but I'm
court.
trying to understand the constitutional issue of whether your client has been properly served so that there can be a judgment against him.
Okay, Your Honor.
And I'm having trouble if you're going to contest possession with the notion that serving him at the premises is inadequate to give him notice that I want the premises back.
Understood, Your Honor.
Okay.
I believe that the answer must be that if a judge, if a court issues a pronouncement with regard to anything that affects a person over whom the court has no personal jurisdiction.
No, it has personal jurisdiction. He signed the lease.
Well, Your Honor.
Signed the lease. Claim arises out of his signature with respect to taking possession of a property in Massachusetts. There's personal jurisdiction. There may not be service, but I can't understand how that could possibly be true if your client is going to contest possession.
Well, Your Honor, you have just stated as a legal matter that there is personal jurisdiction.
What's your argument for how there's not?
That the party had no notice as to the pending action.
That's a service issue, not a personal jurisdiction issue. The claim arises out of conduct in Massachusetts. Your client signed a lease about a Massachusetts property.
In order for personal jurisdiction to attach, Your Honor, I believe it is
They're
necessary.
separate issues. Service and personal jurisdiction are separate issues. You may be, can I ask one more question because it's important? This notice of limited appearance, why doesn't that solve the problem about whether your client had notice?
Because it's not effective notice of the pending action. It
But
is
he signed it, and the attorney certified that he signed a written agreement with the party above to provide the limited representation in the matter.
Your Honor, it is not a substitute for service because it does not apprise a party of the pending action. It only apprises a party of a mediation. That is not the same thing, not a substitute.
Why doesn't a motion to dismiss, why don't you have to raise insufficiency of service in a motion to dismiss? That's what the civil rules say.
Your Honor, because the burden of establishing service is on the party that is bringing suit.
Was there a return of service filed in this case?
Your Honor, I don't recall whether there was a return of service filed in the case. With regard to challenges of service, there is no contest, but that service was made on the apartment in Massachusetts, and the lower court has established that Huang's a resident of California.
But normally, people who have notice and have insufficient service file a motion to dismiss for want of sufficient service. I didn't see that.
Yes, Your Honor, and so this was the procedure that was being thrust on the person who didn't have any knowledge of the service to contest it.
Well,
He must have had some knowledge if he signs a written agreement with Attorney Murphy and signs this notice of limited appearance.
Even attributing all of the knowledge on that sheet there isn't being apprised of a pending action.
There's a lawsuit entitled WATERMARK against Stella Kim and Justin Wang.
There's a title there, and it's the title of the mediation, too. There is no apprising on that document of a pending legal case or a lawsuit. There is only the title of a mediation. And
when your client came in and sought to vacate the judgments against him, what was the process that was followed? Did he testify?
He was queried, and he stated to the court. I don't recall his being put under oath, but I recall his being queried by the court and stating that he had never been to Massachusetts, that he had never lived in Massachusetts, and the court put that as a fact in its opinion, in its memorandum, stating that somehow this didn't matter.
Was he questioned as to whether he'd had notice?
Yes, whether or not he was questioned, he stated unequivocally that he did not have notice, and Ms. Kim stated that she had not provided him anything.
How do we square that with a notice of limited appearance and an affidavit from counsel saying he was representing him in this litigation?
Your Honor, even if the reviewing court is to attribute knowledge to him of that page and the information on it, it does not mean that he had ever been, never been to Massachusetts. That doesn't seem to be
Now
the
you're
context.
confusing service and personal jurisdiction again.
Well, now I can't recall
And they're
the
separate,
question that
you
I'm
know,
addressing.
they're separated in the rules for a reason.
I understand.
They're two different defenses.
Under the statute, there are a variety of transactions by which, if a person engages, it is conceding personal jurisdiction, as I understand it. Some, but there are administrative court, appellate court cases where co-signers of leases have been deemed not to have received the necessary service necessary for the party suing them.
All right, thanks.
Sure, that's true. All right. Well, that's a little more than the 16 sentences that were predicted, but
Okay.
I think that's entirely on our side, not your side.
Thank you, Your Honor.
Thank you. Whenever
Good
you're ready.
afternoon. May it please the court, Attorney Vladimir Nechev on behalf of the appellees, WATERMARK II Member LLC. I'd just like to start by first, I'll go in reverse. I'll address the point that my brother addressed first as it pertains to Mr. Huang. Mr. Huang did in fact sign a lease agreement. And as part of that lease agreement, I believe on the very first page, he did not sign it as he signed it as a co-tenant, as a lessee, not as anything else. Furthermore, he specifically agreed in the lease agreement, by signing the lease agreement, that the address in Cambridge will be used as his primary source of residence.
And you're using that as a basis for service of process by leaving it
At his last and usual place of abode.
Well, what's the proof that it's his last and usual place of abode? Just the fact that he signed a lease where he said he was going to live there?
Well, the only two, at the time the case was commenced, the only two addresses that we had. Now, mind you, Your Honor, this is a apartment complex of over 150 units. The client does not see every single resident that comes in and out of every single apartment.
Right, but that's the issue, right? I mean, you know, you have a $58,000 judgment against him, and there's no evidence that he was ever seen in Massachusetts, let alone at that particular apartment. And you're saying, well, I left it at his last and usual place of abode.
Correct, in accordance with the rules. The only two addresses that my client had, as it pertains to Mr. Huang, was the address on the application and the address.
But that doesn't matter. You need to prove service of process. Was there a return of service
Yes, there was.
filed? And what did it say?
That it was served at his last and usual place of abode, to the best of by constable at the.
Did anybody at any time in this case put in an affidavit or anything that says, hey, I've seen him there. That's where he lives?
No, I don't believe there was an affidavit to that
The reason
extent.
for that is because it appears that he never, ever set foot there. So you want a $58,000 judgment, and you want it to be enforceable under circumstances where the only service of process was leaving something on a doorstep that he'd never been at.
And mailed as well to him at that address,
Yeah.
mind you. But
That's problematic,
well,
isn't it?
If he signed the lease as a guarantor, it may have been problematic because it naturally gives rise to the fact that this person is not a tenant of the apartment complex. But signing the lease as a tenant and swearing that that address will be his primary residence, not secondary residence, not I visit
But
occasionally.
he has to have notice. If you want a $58,000 judgment, he has to have notice. I mean,
Well, he had
I'm
notice.
troubled by the notion that he could contest possession. And so I'm struggling with this, okay? Because it seems to me I don't see how he can contest possession. All right? He says, I've never been there, and you leave something at the address you're trying to get possession of, and they say, well, since I'm not there, you couldn't get
Correct.
possession.
It's a circular
How can that
argument,
be?
essentially.
But I'm a little bit, I'm also troubled with the notion that you can get a $58,000 judgment where he never had notice of the case. Now, maybe he did. What about this document?
Well, my first point was the fact that he signed it as his primary residence. I was tying that to Rule 4D as it pertains to last and usual. I believe that document actually contains the docket. It's not just a mediation document. Mediation in the housing court is the first step. It contains a docket number. It's clear that there was an action pending for eviction. My brother makes the argument that
Is the case law, and I've forgotten this, I haven't looked at it in a long time, but is the case law that even if you don't satisfy the language of the statute as to service, you can still establish service because you can establish actual notice?
I believe it is, and I believe part of the argument is that the notice of the actual pending litigation was given when I believe it was Attorney Murphy that filed the limited appearance, stating, now my brother states that he wanted a continuance, Attorney Murphy that is, wanted a continuance for the mediation because he had not had substantive discussions, but a substantive discussion regarding a meaningful mediation is different than a substantive discussion to file an appearance on behalf of somebody. That includes a docket number that clearly represents a pending case.
So what do we do with the words limited appearance?
I don't think that necessarily comes into play because I don't think an attorney would file a limited appearance without having a conversation with Ms. Kim and Mr. Huang.
Yeah, but you know, there used to be this concept that you could come into court, I think it still exists, and you could say, I'm appearing on behalf of this defendant, but I'm not waiving service of process as a defense.
So I believe one of the...
And it used to be called, I think, a special appearance or a limited appearance.
I think that still exists, but I think the way it's done, at least in the housing court, is the lawyer for the day practice, where they come have a conversation with a lawyer, he appears on their behalf, but he's not waiving anything just because he has appeared on behalf of a tenant does not mean that the tenant is actually aware that there's a pending litigation. Sometimes they're mediation, sometimes they're things that are outside of the mediation. This one is a pending litigation.
I thought these things meant the attorney is only appearing for this little part of the case and is not agreeing to appear for the whole case.
Correct. They usually file a notice of limited appearance for the mediation, then they file a withdrawal. But in order to file, now mind you, this was not on the day of the mediation. This was done prior to the mediation because that was emailed to our office. As part of that notice of limited appearance, there is a pending court action, and the mediation is the first step of that pending eviction action. So between that and the fact that, and again, I go back to the fact that he signed it as a leaseholder. People travel for work all the time. There are people that go into an apartment less than half of the year, but that doesn't mean that that's not considered their primary place of residence.
Here's the hypothetical that really causes me trouble with that, okay?
Sure.
You send somebody a notice to quit. They say, you know, they're absolutely right, I'm out of here. Their co-tenant sticks around, but they're gone, okay? You then serve them with a summary process complaint at some place where they've left, okay? And you get a judgment against them for the unpaid rent without them ever having notice of the case at all, because they've left, they've bolted.
Well, I think in your hypothetical, Your Honor, you're kind of removing all sort of liability on behalf of I'm leaving, I'm not forwarding my address, good luck finding me. Well, you did live there. That was your primary source of residence. That is where under 4D, the service would have been done.
You could get a judgment for whatever you wanted, because you never gave that person service of process. They have no idea that the lawsuit's been filed. They left, they quit, which is what you asked them to do.
Well, we served it at the last and usual place of abode. If he just left and was hiding, there was no...
Not hiding. You literally sent him something called notice to quit.
Correct.
And he said, okay, time for me to leave.
Well,
and he went to another state and you never served him. You think the judgment that you get under those circumstances would be enforceable?
There's nothing in the record until his motion to vacate the default that he was in California. Nothing. The most recent address that we had on him, because
Nothing in the record that he was at your place either.
Yes, there is. There's a lease agreement that he signed as a leaseholder stating that that is his primary source of residence and a limited appearance. Notice that stating that he's aware of not only a mediation, but a mediation as part of a pending eviction action against him for possession and damages.
Let's talk about the ledger, because I didn't see any foundation for it being a business record.
So I believe the testimony that was provided by the keeper of the records that the ledger is kept, it's a running ledger of charges and credits and payments that are made that includes other things in addition to rent.
But where did she say this is kept in the ordinary course of business? I didn't see that.
I believe, I don't have the record right in front, but I believe I asked her, is this document kept in the ordinary course of business? And she responded, yes. But there was also there was an objection as to other charges by Ms. Kim, but there was no objection as to the rent. As a matter of fact, she acknowledged that she owed the rent.
Well,
those specific months.
She acknowledged some of the rent. I mean, the problem with this case is until August 16th, we know exactly what the rent is. But after August 16th, the rent is the market rate at the time of the applicable extension for a comparable apartment in the development plus a month-to-month premium of $1,000. And other than the ledger, what evidence was there of what the market rate at the time of the applicable extension for a comparable apartment in the development was, other than Ms. King, who said it was much less than what this judgment says?
Ms. Kim did not testify that the market rate for her apartment was much less. She testified, or she attempted to testify, that the market rate for similar apartments was less because she had a lease.
Similar and comparable is different?
I'm sorry, Your Honor?
Similar and comparable, you're drawing a distinction in those two words?
No, I meant that she testified that other apartments in the building, not necessarily similar apartments.
That's what this lease says. It says after August 16th, the rent is the market rate at the time of the applicable extension for a comparable apartment in the development plus $1,000. So where, other than the ledger, was there any evidence of what that was? I didn't see that.
There wasn't. I think there was. Ms. Kim tried to introduce a renewal offer at the time that the lease was expiring that stated what, if she didn't renew for a period of 12 months or 8 months or 10 months, what the month-to-month rate would have been at that time. But there wasn't, which is why that was not charged or requested, the market rent. It was the lease rent plus
But that's not what the lease says. The lease says it isn't the lease rent plus $1,000. The lease says at that point, it becomes comparable market rate plus $1,000. So if there's no evidence of damages, of what the damages are after August 16th, then isn't this number, $56,760, just completely wrong?
No, because I believe that there was a lease agreement that stated what the monthly rent was, and if there's, in the absence of evidence, you go to the four corners of the document that says that the rent increases by $1,000. Now,
It doesn't say that. That is not what the lease says. I'm looking at this lease. Maybe you should look at it too, because what it says is that after August 16th, 2020, the rent is the market rate at the time of the applicable extension for a comparable apartment in the development plus a month-to-month premium of $1,000. It doesn't say the old rent plus $1,000. It says that. So to get damages after that point, don't you have to prove what the market rate was for comparable apartments in the development on August 16th, 2020?
Right, I think there was as I mentioned, I think there was a renewal offer, which Ms. Kim ultimately did not accept, that stated what the market rent was at the time. If she were to not accept any longer-term period, like a 3-month, 6-month, 12-month lease agreement, then it would default to the month-to-month rate, whatever the market rate was at the time. She didn't accept that, so the trial judge did not make it as part of the evidence. But I see Your Honor's argument. It's just the market rate at the time that the lease expired plus the $1,000. My position would be, at the very minimum, my client should be allowed to collect the rent that was due under the lease agreement for the month, for the fixed term of the lease agreement.
Why?
because that's what the parties had contracted to.
That's not what the parties contract. I've read the contract 4 times now. I'm not going to do it again, but that's not what it says.
No, I think, if I could, I think what he's saying is at the very least, the judgment should have been through the end of the lease, as opposed to the extra months. Is that what you were saying?
Correct. I'm saying
Through August 16th, 2020, right?
That's what I'm saying.
Is that what you're saying that the damages should have ended on August 16th, 2020?
Correct, and if
But they didn't, right? It's much higher
At
than
the
that.
very least, he said.
Well, yes, because the judge took the trial court argument to mean that I'm allowed to, or the client is allowed to charge the month-to-month on top of the market, on top of the lease rent as opposed to the market rent. But under your
Found
honest
that
theory
you
that...
didn't prove it, the remedy would be to send it back for a retrial on damages?
If it would be just on the monetary damages, but I don't think under that theory that defeats the issue of possession in any way, shape, or form.
Oh, yeah, no, I get that.
So, yes, if it were to get remanded just on the issue of damages, that's one argument, but my client, because possession is still an issue, I don't think whether it's, and I'm just paraphrasing numbers, whether it's $55,000 or $20,000 or $30,000.
Is the tenant still in
I
possession?
get, you're saying,
Correct, yes.
you're saying there was enough damages to justify possession for you regardless of this?
Correct, especially because
All right, I
the
get that.
counterclaims that were testified to by Ms. Kim were not, she did not testify that the
Tenant
mold
is
was-
still in possession how?
There was a single justice issue of an appeal bond order, and for some reason, the single justice only ordered that Ms. Kim pay $1,300 a month to keep the appeal going.
And she's been doing that?
She's been paying the $1,300.
Okay.
And I don't know if it was exactly $1,300, but it was $1,300 and some.
Okay.
But so I believe that it doesn't defeat possession, especially because the fact that she didn't testify. She was not allowed to testify that the mold was black. She was allowed to testify that there was a speckle of something. She was not a mold expert. She was not able to testify as to any drug activity. So I don't think any of the counterclaims lie weight, and I think my client should still be entitled to possession. And if the court were to remand it for a trial separately on the issue of damages, then so be it.
That's one final question. Do you think a judge has discretion to allow a late jury trial demand?
Not under the summary process rules. I think they use a shall statement, and I think if it's late, and it actually, if I could just clarify that point, the initial mediation was on February 3rd. It was not 5 days late. The standing order specifically says it's due when the answer is due. The answer was due 3 days prior to the first scheduled mediation, which was February 3rd. It just happened to be continued. The only argument made by counsel at that time as to why a jury trial should be allowed was, it's in the answer, you're allowing my answer, therefore a jury trial should be allowed as well.
As long as it was late, it doesn't matter how late it was.
That would be my...
I mean, under what you just said, as your interpretation of the rules. All right, this is actually a very complicated case, maybe more complicated than everyone appreciated, but this has been really helpful, this argument. So thank you both very much.
Thank you, Your Honors. Thank you for the time.
Oh, boy. Wow. Yeah. Exactly my thought.
All right, home stretch. I'll call the last case of the day, 23P 55, TRETHEWEY versus TRETHEWEY. I'm not convinced I got that right.
Yes, Your Honor. Thank you very much.
Whenever you're ready.
Good morning, Your Honors. Good afternoon. Marty Kane from McGrath and Kane on behalf of Michael TRETHEWEY, and with me is Rob Curtis. May it please the court. Michael is here asking this court primarily to do two things. One, he's asking this court to stay the financial provisions of the divorce judgment pending the issuance of this rescript in this appeal. And he's asking you to reverse or otherwise vacate the divorce judgment with respect to the division of the marital estate, alimony, and the attorney's fees.
Stay the financial provisions of the divorce judgment,
Yes, Your Honor.
including alimony.
Yes, Your Honor. Which is not being paid right now. And I think the court has the authority. It did it in Fan and Steel when Fan and Steel was here. I think it's Appellate Rule 6A1. And Fan and Steel, as this court knows, issued here. One of them asked for further appellate review to the SJC. The SJC took it. It was briefed, argued there, and an opinion came out. That duration was about 2.5 years from beginning to end. I don't expect it'll take that long here. But we've been asking for the stay relief repeatedly as this court.
You didn't actually ask for a stay of alimony when you first started. When was the first time you asked for a stay of alimony?
That's correct. In my argument in the brief that we've filed, I want to be clear. There's the only two that we're asking about SJC, single justice appeals, were the one of January 23 and March of 23. January was after he was found in contempt in December of 22 by the trial court, different judge, not the trial judge. And we asked for it there, and obviously.
So you asked for a stay of the alimony in January of 2023 for the first time?
Yeah, we asked for stay for everything, Your Honor. Yes, it was really hitting. It was hitting. The rubber was hitting the road. Then we forecasted this. We knew this was coming.
What remains besides the alimony? You said the financial aspects. There's the alimony. What else is there that hasn't happened yet?
Well, the most important issue in this case is the double dip.
No. Your client's been ordered to do a bunch of things. Which ones hasn't he done?
He's done everything he could do to his ability, Judge, before
but
he
which
was
ones? If we're going to stay something, we need to know what we're staying. We're staying alimony. What else remains undone that we would stay?
There are open payments that are to be made from the husband to the wife that have not been made.
Which payments are those?
One of them, Your Honor, is you will see in the court when the trial court tried to equalize, and there was a typographical error.
Yeah, $675,000 you say. They may say $775. That hasn't been paid yet?
No, Your Honor, a third of that has been paid, yes.
A third has been paid because it was over 3 years, is that right? Or three?
There was a time period, I don't think it was 3 years, but it may have been close to that, Judge. It was 225, I think. 675 is what the court wanted and made sense mathematically under the Table 1 that we have, but it was 775, I think, a Scrivener's error in the judge's findings.
But why hasn't the rest of it been paid? Because it's not due yet?
No, the rest of it hasn't been paid, Judge. The third piece may not be due. The second piece was due, I think, December 1st. It hasn't been.
What year?
21. It hasn't been paid because there is no money there to pay.
There was no money to pay it as of December of 2021?
There was no money to pay it as of December. There was money to pay it as of December of 21. I think I take that back. That was the first installment, Your Honor. There is no money now to pay it. The first installment was paid. There's no money now to pay it because he lost his job. And he lost his job.
He had $3.2 million sitting in an account that was all allocated to him.
That $3.2 million.
As of 2019, right?
As of 2019, there was $3.2 million in the Wells Fargo account 088, which was the whole loan proceeds, the advance of his bonus. He owed at that same time there was 3.2.
Yeah, I don't want to hear about that yet. Because he didn't owe it back until the point at which he stopped having the job, which was years later. So I'm not going to be confused because I've spent a lot of time with this. I think enough time to understand it. In 2019, he had $3.2 million sitting in an account. And you're saying that in December of 2021, he had no money to pay the rest of the $675,000?
I'm not saying that at all.
Okay, well then I don't understand.
Right, he paid the first $225.
Okay.
He has the question that was posed to me earlier, and I have no intent to confuse this court. The question was posed to me earlier was the subsequent payments. So while he had $3.2 million in that account, the Wells Fargo account, that 3.2 had not been earned. As the court knows, as it's read the opinions, the 3.2 was getting earned at $51,000 a month if he met metrics.
But that's irrelevant to me. He had the money. It was sitting there. I don't know why, this is why I stopped you. I don't know why you're going off on the fact that it hadn't been earned. I understand it hadn't been earned, but he had it. And he was using the money from that account to pay things.
Yes.
Okay.
And the judge found he was using that account to pay court-ordered approximately $35,000 a month in alimony and court-ordered payments under the division of assets. The original $35,000 came out from Justice Dunn's order in April of 2015, where he required $14,250 to be paid in alimony, and then...
Okay. I've got this in front of me. So let me do it this way. So the order was that he was to pay $675, or maybe they think it's $775. I don't know. I'm not here to resolve that. But it was $225 on July 1, 2021, $225 on October 1, 2021, and $225 on December 1, 2021. Are you telling me only the first of those three payments was made?
That's what I'm telling you.
Okay, and the other $450 has never been paid. There was also an order to pay $155,000, which was related to the Florida property. Was that payment made?
Paid. Paid.
Okay, that's paid. So am I right that in terms of the adjustment of actual out-of-pocket from your client as a result of this, which I had trouble following, it's the $675 plus the $155?
Oh, no, Judge, there were attorney's fees on top of that. It's $130,000 in attorney's fees. There was properties that needed to be sold and money going over. And I should have informed the court, I didn't try this case over 19 days between 2016 and 19, or 17 and 19. And so I apologize. But I do recall reading in the court's findings, the trial court found that he relied on that $3.2 million to pay his living expenses, which the court deemed to be $10,000 a month, as well as the court-ordered fees and the expenses, which equated to, at that time, prior to the judgment of May of 21, about $35,000 a month. There were college costs in there were carrying costs in there for all the properties, and there was a $14,250.
So let's say that all adds up to roughly $50,000 a month or $600,000 a year. He's got $3.2 million. He's paid out of that $500,000, a little bit less. So that's 2.7. So he ran out of money when?
He ran out of money, Your Honor, I would say in August, I think, of 22. Remember, the whole time he's paying $35,000 a month.
I just added it all up. $600,000 a year.
Well, that's 1 year, right?
Yeah, so at 2.7 over, that's over 4 years, not...
I'm sorry, I don't follow you. You're on 4 years, what?
2.7 million, which is what he would have left after he pays 225 plus 155 plus 130. Okay? And he's spending at a $600,000 a year pace starting in 2019 when the trial ends?
He was paying $35,000 a month from April of 15 all the way through. The judgment changed it to a hard $34,999.
Right. I get it.
In May of 21. But it was that same amount.
But he also had income
Right,
too.
and that's the fundamental problem. The income that he had is $600 plus or minus $650,000.
And that was being used to pay the 35 to pay the alimony, right?
35%, Your Honor, on $1.2 million, which is the rub of the double dip. He wasn't making $1.2 million.
I understand the argument about the double dip. I don't understand how your client ran out of money. And when you come in here and you say, you need a stay now, we need to understand that.
Okay.
Okay?
So with regards to the stay, he's been fired from his job. He has no assets coming in now other than starting up a new business where he has an apartment in a condo in Miami where the bedroom's on the left and his office is on the right.
But he had $3.2 million sitting in an account. And I don't understand how that is zero.
Because the $3.2 million, Your Honor, was as of May of 21. It's now November of 23. And the number of 3.2, the court needs to understand, and maybe this is why I missed it, is that number of 3.2 was on the last day of trial. So
2019. I get it.
So 2 years later, when we get the judgment in 21, he's using that money, as the court found, to pay all of these expenses at $35,000 a month plus his $10,000 a month.
He has $600,000 in income too.
Judge, there was only $1.2 million $1.3 million, $1.4 million left at the time the judgment came out. At the time the
How
judgment...
did that happen? See, here's the way I see it, and this is why this is very difficult and confusing, okay? He doesn't have $1.27 million in income. He has $670,000 in income,
Plus or
right?
minus, I agree.
But he's got $3.2 million sitting over here.
In 2000, last day of trial, 2019.
2019.
And he owes 4.8
Of that
on that.
$670,000, he's paying alimony of 400 and something, and he's paying taxes on 1.2 million. Or no, less than that, because the alimony comes out. So
Deductible,
he's
yeah.
paying taxes on 800. By the way, that comes out roughly to $670,000. So let's just call that a wash. The income is going to pay the alimony and pay taxes. But he's got 3.2 million over here for his expenses alone, independent of taxes. And somehow that has disappeared almost entirely.
No, I respectfully disagree, because in 2019, which is the date the court uses, 3.2, he's still under the obligation of justice done before the $35,000 comes out. So he's covering everything else. It's not a wash of $675,000. He has 3 children. He's paying college expenses. He's carrying mortgages on properties. He's paying health insurance, life insurance. All of those expenses that he, as the sole wage earner,
was $1.9 million. That was $1.9 million out the door over the next 2 years? Because it was you say it was 1.3 at the time of the trial concluded?
I would say
I'm sorry, that the judgment came out. Judgment comes out.
The judgment came out. It went down a couple of $1 million, and I can find the exact amounts if the court needs it. But yes, following the court, yes, and because he was paying for everything, and he had to.
Well, he wasn't. He was paying alimony at that time of roughly the same amount, right?
Well, no, the alimony at that time was $14,250, as established by Justice Dunn. No, but he also had every carrying costs of the whole entire family. So each child's car insurance.
$1 million a year?
Probably. These people lived a very good lifestyle, Your Honor. Yes. I think the double dip is where we need to be focused in this case, because the court did not follow the rules as laid out by this court and the SJC. The Champion case, DeLessio case, Ludwig, Adams, each one of us, those cases, say, look, we don't like double dipping, but if you're going to do it, you have to make sure that, and make findings, that it's equitable and that you can separate the basis, as they did in DeLessio and as they did in Champion.
Let's assume we agree with you on that. What do we do about it? Let's assume that you're right, and we agree that there was a double dip, that in fact the judge should not have both used the income for purposes of alimony and also split out what was left of the $5 million, or you would say $4.8 million, either 4.8 or the 3.2. I don't really care for present purposes. We'll have to solve that somehow. But let's assume you're right. What do we do about it now?
Send it back, Judge. You need to remand it.
And what do you think is going to happen as a result of that? What are you going to ask for then?
I'm going to ask that equity be established. The probate and family court's a court of equity. There's been no equity in this case. This gentleman, was left with zero. And my brother's going to come up and say because he had a girlfriend and he did this, that, and the other thing. Well, listen, has nothing to do with the marital partnership of 21 plus years as found by...
Look, you're not going to be able to file something on remand saying just do equity. You're going to have to ask for some specific things.
Yes.
And we'd like to know what those things, and you're not going to commit to this. You can decide something later. We're just trying to get an idea of what kind of things you're going to ask the judge to do to untangle this.
Certainly, Your Honor. Thank you. With regards to the property division, the judgment, and I'm not pointing fingers, we had this thing called COVID, took 22 months to come out. And from 2019, as I just went through with Justice Englander, to 2021 when it came out, a lot of things happened. Money was spent. Valuations of the house went up by $800,000. When you look at the accounts, the 888 account, that was down to $1 million and change because everything was being paid from it. The other Wells Fargo account, where the court found he was putting his income, had gone from $300,000, I think, to about $700,000. That's after payments are made. That's where some of the other money went, to answer the court's previous question. The wife got 80% of that. So I would like to look at those big-ticket items.
Sounds like a complete retrial with a complete set of additional financials. That sounds like what you're asking for.
I'm asking that some justice be given to this gentleman.
That's, you know, we are here to do justice, but we're asking you for specifics. The end of your brief comes very hard at this court, and it says, you guys haven't done anything, so we're giving you the opportunity to tell us what you think we should do.
Thank you.
It seems to me to be very, very complicated. Are you suggesting, because this is what it sounds like, that you're going to have to go back and you're going to have to redo what current income is, what the assets are, what they've been for the last 5 years, and redo the entire process? Is that what you're suggesting?
Yes, I think this is one of those very rare cases we have to go back and we have to look at what is the income today and what are the assets. And that's going to be a tall order. There's no doubt about it. But I think that's the only fair way to resolve this.
Sounds like most of the assets are going to be depleted on attorney's fees.
Well, I don't know if that's true or not. I don't think so. The assets were significant. There was $4.8 million according to what the judge found at the time. There are properties that are still available. There's a house worth $1.5 million down the Cape.
Have the two Cape houses been sold?
So one was transferred, the wife has possession of the one, and the other one was sold, yes.
So when it was transferred to her, she was supposed to pay to the husband something, is that right?
No, I don't think so, Your Honor. I don't believe that's right. No. The only monies were going
All right.
one way. I see that I only have a few minutes left.
You are 2.5 minutes over time.
This is going to be all my fault, and it's on me, and it's the last one of these. It's been a long day, but I may have some further questions, and it's not your fault that we're over. So I apologize, Judge. But
do you want to keep going?
Well, first of all, let's give him a chance to say what he hasn't had a chance to say because of me. But.
Okay, so I'll give you another 3 minutes, and then judging, then we'll have at you again.
Thank you. I appreciate that. With regards to the double dip, it's clear that this is a double dip. There's no doubt about it. Also, the division of the marital estate, the court needs to look at the division of the marital estate and ask, was it equitable? Of course, the probate and family court judges are the trial court judges that are afforded the widest latitude from this court and the SJC when it comes to decision making. But it's not.
Here's the question I had in mind. The $1.27 million that the judge determines is his income as of the time that she enters her order, right? So I guess that's the income that she uses for purposes of alimony.
Yes,
did that include any unearned income from investments?
That did not include unearned income. It was earned income from his job at about $650. The court and I would agree, and it was $51,000 a month, that was forgiven over the 12 months for another $600,000.
Did the financial statements disclose unearned income from investments?
Oh, I believe they did, Judge. Yes, the first page, you've got to put that on there. Again, I wasn't the trial, but of course, any law firm is going to do that. It would be on there. And of course, they were joint at the time of the divorce. They were jointly owned. They were filing joint returns, so they're both paying, the capital gains tax, if that's or interest and dividend income, if that's where the court's going.
Not just interest and dividend, but accretion in value. I assume that the $5 million were taken and invested. That was his job. That's what he did. I could be wrong. I don't know if there are any findings on that.
Which $5 million, Your Honor?
$5 million that he got up front?
Oh, the $5 million that he got up front. Yeah, I agree. He could have gone to Vegas and put it on red or black the day he got it, or he could have marshaled it and every month when it was received, paid it that way and never touched it. But it was invaded, and it was invaded not just because he had a girlfriend in Miami. It was invaded because he had 3 children and a wife and lived in a high upper middle class lifestyle with country clubs and everything else. I will rest on the other issues, Your Honor, the attorney's fees, just to say that it is a property division. He is entitled to due process, and the brief clearly states out that no due process was provided to him. He has a right to notice and right to a hearing, and neither of those two occurred on the $132,000 which he has paid. And finally, with regards to the denial of the stay, I don't mean to come at this court, and I apologize if the court interprets my brief that way, but it was It was as clear as day to the trial courts after this came out, at least when I got
I'm not
involved.
challenging zealous advocacy. I'm just saying that we need to know what it is you want when you're...
I appreciate it, but I didn't intend
No, it's fine.
to be critical of the bench. And I thank you. I thank you for the 3 minutes, Justice Ditkoff. Thank you.
All right. Counsel, we're going to start at 15, but you are also allowed to go over by 5 minutes and 52 seconds if you choose.
Thank you, Judge. I'll try not to use it. I know it's been a long day for everybody, and I appreciate your attention. My name is David Cherney from the firm of Atwood & Cherney in Boston on behalf of the appellee, Rose TRETHEWEY. With me is my colleague, Thomas Ritter, who helped me write the brief in the case. Like Mr. Kane, I was not trial counsel in this case either, but I'm not saying that I am not held to the standards of knowing what happened at the trial level, just the same way as it's been presented to this court in the record appendix. What's important, I think, first and foremost to consider in this case is that Mr. TRETHEWEY is not challenging any of the findings made by Justice Black in this case. Right in his brief, he says, I'm not challenging them, the subsidiary findings, and that's key because what he is saying is, I don't like what Judge Black did. I don't like the judgment she issued. I'm not happy with it. But that is not the basis for appellate review, for this court's review, and especially for the type of reversal that Mr. Kane is asking for. I agree with Your Honor. What he's basically saying is, send the case back, look at what's there today, ignore the fact of all this money that's been spent by Mr. TRETHEWEY from when he had it, because remember, he had $5 million paid to him when he changed his job in the middle of the trial to Wells Fargo.
In 2018.
2018. And that was $5 million tax-free cash that came to him. And he, as Your Honor pointed out, could have done it. He was an investment advisor. That's what he did, and he did it very well. He had millions and millions, hundreds of millions of dollars of fees that he was generating.
Right, but their argument, there is a legal argument here, right? And the legal argument is that the order that was entered is a double dip, and that it needed to be justified if you're going to do a double dip. Now, you, I think, in your briefs contest whether a double dip even occurs.
I do.
I have trouble understanding that because there's no question, as I understand it, I don't think you can test this. The $1.27 million in income included $600,000 that was the $50,000 a month from his, from the Wells, whatever you want to call that payment, right? The transitional payment.
I agree with that.
Okay, so her alimony is based on income that comes from the transitional payment. And then the judge also ordered a division of assets which included $3.2 million that was that transitional payment.
It's a different animal than if he was actually receiving the payment every month and then putting it into a bank account and having it grow. As we know, and what's clear, is this was a front-end loaded payment that he received of $5 million to do with whatever he wanted. And what he should have done, I guess I should have, would have, could have isn't the issue here, but he could have paced himself out. I mean, I think...
But that's not answering my question. Isn't it a double dip?
I don't see it as a double dip because...
The $3.2 million were left over. Those $3.2 million were split.
Well, it was $3.2 million after he had already gone through $1.8 million of it. I think the big question is where, Your Honor said, where is the money? I have that same question. Where did that money go?
But we got partial answer to that, right? I mean, we didn't get it at a detailed level, but we got an answer that said, if you look at what he's spending, we're running from 2019 to, let's call it January of 2023, at which point I understand that his job concluded. So that's a period of 2.5 years. He's using that for his personal expenses because his income is going to alimony and taxes.
Well, as you pointed out, he gets the deduction for the alimony being paid. It was treated as a tax deductible.
Right, so let's call it 30% of $800,000. 240 plus 430 equals 660, which is pretty close to 670.
And it was probably higher than 30%.
But, I mean, it would be taxed at her bracket. Well, the deduction for him, he's at the maximum bracket. So I think, as the court found, he was at about a 45% rate. So he was receiving the benefit of 45% of that annual
But
alimony.
this isn't getting to the answer the question. I'm assuming, and so far no one has disabused me of this, that the income he was actually receiving was going entirely to alimony and taxes, which means he had to access the account for his personal living expenses and whatever other costs he had to bear between 2019 and the beginning of 2023. Now, $1 million a year sounds like a hell of a lot of money, but it doesn't sound like out of this world.
I understand that, and I think the real question is when you look at the judge's findings about what the needs of the parties were, because that's what alimony is based upon, need and ability to pay. And the first question you have to ask is the information that's been presented by the litigants. And the judge found, the trier of fact found, whose findings are not being challenged, that the husband's less than candid behavior during the proceedings, willful attempt to shield assets from the wife during trial, dissipation of assets, voluntary resignation from employment during trial, require...
Let me ask it this way. I'm going to ask the backhand of the same question I asked your opponent. Let's assume, and I know you don't agree with this, that we think a double dip occurred and that we think the double dip was significant enough that it means that the judgment has to be revisited. What would you think needs to be done under those circumstances?
If the court sent it back with that revisit, then you've now opened up as to not only what was there at the time that the divorce judgment entered in 2021, but also what's happened to the remaining money from that date to this date. And that's why I say the findings that Judge Black made about this man's credibility and his reporting are critical to the findings that she made. I mean, she made specific findings about each party's levels of income. My client...
That's not a... Okay. So she said that he was less than candid. How does that help us if we decide that legal error has occurred? How does that help us shape a remedy here?
I don't know that I don't know that it helps this court shape the remedy. But what I'm saying is, when they stand here today and say he's spending $1 million, just spending $1 million on what? His credibility, and that's a big issue in all these divorce cases we try every day in the probate and family court, is the credibility and the believability and the presentation of evidence, which the trier of fact is the one who is tasked with assessing and going through it and making these decisions. That's what Judge Black did, and that's a critical finding in this case. And it's not just one finding.
How does it, I'm sorry, counsel.
A man cannot be...
It seems like a non-answer to the problem that's presented to us if we agree that there was legal error here. If we agree there's legal error, we have to figure out what to do.
Judge, I'm saying...
The fact that Judge Black was unhappy with testimony doesn't answer that question.
What I'm saying to you is I think it's as simple as if you were to remand it on that basis, then we go back, as I said before, to what was there at the time of the divorce, and then what's been done with all that money since that time. And we find out what Mr. TRETHEWEY has been doing with his money, and what he's been doing with his earnings, and why. I mean, Mr. Kane said he lost his job at Wells Fargo. Well, why did that happen, et cetera, et cetera. We're talking about a proceeding that could take another 19 days to try. I would hope it wouldn't, but it's that complex. The issue here is, have they shown reversible error? Have they demonstrate that the judge abused her discretion or committed an error of the law?
Well, so the judge...
I'm sorry?
The judge says is trying to split it more or less evenly, a little more for the wife, and yet gives almost all the liabilities to the husband and none to the wife. I mean, why isn't that error there? What the judge did was contrary to what the judge was trying to do.
First of all, we haven't filed an appeal on her behalf, number one. But number two, there were other liabilities. There was the biggest liability. There were liabilities that she had. She had taxes that were due. She had legal fees over and above the $130,000 that she was awarded and the earlier fees that she had been paid. And you'll see if you look at her trial financial statement, it's in the record.
There's a finding as to what her liabilities were.
And a finding, exactly.
Yeah, but it's a few $100,000. It's not $4.8 million.
But every month, his $4.8 million is being reduced by $51,000. Hers, even at $200,000, and I agree that in relation to $4 million, it's smaller, but hers isn't getting reduced. If anything, it's building every month. And now especially because she hasn't been getting any alimony since last April.
Since last April? Oh, April of 2023.
Yeah.
Yeah.
But that's it's pretty significant, at 34
How are
grand
her
a month.
liabilities building? She's getting paid $400,000 a year. She's got a couple properties to live at that are being paid, as I understand it, in part, at least by him at the time. How are her liabilities building through the last 2 years?
She has all the expenses that she has to pay. They sold the house in Winchester as was ordered by the court. She got proceeds from that, but now she's living in the Cape House. That's her residence.
How much proceeds did she get?
I'm just sort of trying to do it backwards because I said it was over $1 million. I can tell you that.
And did she, under the way that the assets were divided, did she get the entire equity of the Winchester house?
After all costs and expenses, and there were issues about the husband's delay
I'm having
of that.
difficulty seeing how her liabilities are building, counsel.
Well, Your Honor, if she's used to living at a lifestyle of $400,000 to $500,000 a year, and now all of a sudden she's getting $400,000 a year in alimony, which she has to pay taxes on, so it's that much less. And if now she has these expenses that she's got to pay that he was paying before, I don't think there's a question that those liabilities and her shortfall is going to bend. Because the reality is, as Justice Black found, her expenses were X dollars. And she found that they could clearly be met by the payment of alimony and that he had the ability to pay it. Justice Black had a full understanding when you read these 87 pages of findings.
Her expenses were less than $400,000. They would have been less than the alimony minus the taxes.
And if not, her responsibility would have been to reduce her expenses, to live within the means that she had. Just as it's Mr. TRETHEWEY's obligation that if he claims that he can't afford it, and he hasn't filed a complaint for modification, and whether he'd have to come to this court first for permission to do that or not is a whole question, but that's where we are. In terms of, if I can just skip ahead quickly to the issue of the stay.
But he did ask to modify. I thought he asked to have the alimony reduced, and the judge refused to do it very recently, within the last few months.
There was not a modification action filed. There was a contempt proceeding that's subsequent to this record, but there was no modification required. My understanding, I was there one day, and my understanding was he basically said, I don't have the money to pay, I'm not going to pay. And that's it. And he owes her $450,000 still in those lump sum payments. He owes her some $175,000, whatever $34,000 in alimony from April forward is, and he's just not paying her anything, nor is he asking relief from the court to not pay it. So I'm just saying that this man, who's on 9 separate occasions, by my count, has requested either that the probate court stay matters, or that this court's single justice stay it, or that a full panel that heard his appeal of the single justice's denial of that stay, of additional requests for stays, of requests to the SJC for further appellate review, and now before you now, 9 occasions he's requested a stay, and nobody has found that he has met the criteria that would mandate or require that.
Now it's in front of us to decide whether the judge committed legal error, and all those others were preliminary. The second issue raised by your opponent has to do with the date that the judge chooses to value assets. Doesn't the law say the judge needs to choose a date?
I think what the law says that typically it's as of the date of the judgment that it comes out. And in certain circumstances, like under the Savides case, where there's a significant length of time of separation and a significant change in assets that in no way, shape, or form could be tied to the marital partnership, that upon findings by a court, that the court can make a different time to frame it. But other than that, it's the evidence that's before the court and over the 19 days and the hundreds of exhibits that were filed in this case.
So you think that as of the time of judgment is the default rule for how you would value the assets?
That's all the information the court has before it. Yes, I do.
But it seems like the judge valued the assets based on the last day of trial, not the day of judgment.
But what he then came in and filed a motion for a new trial, alleging, among other things, that the value of the marital home that was being sold and that she got the proceeds of had gone up, that the value in the account that was supposed to be divided went from $300,000 to $800,000, so he's now getting penalized by having to pay her more, and some other things. He doesn't mention things that, financially impacted him well. But that was filed, and there was an opposition filed, and the judge denied that motion for new trial. That was the appropriate methodology and way to approach it. And
But
that
there has
was
to,
denied.
I'm sorry.
I don't understand. You told us that you're supposed to value everything on the day of judgment, and the judge valued everything not on the day of judgment. So why isn't that reversible error? I don't know why it helps that the judge didn't fix it afterwards.
And what I'm saying is the judge, the values on this judgment are as of the date of judgment. I agree.
Well, but no,
that
the judgments in these findings are all, none of them are day of judgment valuations. They're all valuations from earlier. I think mostly the last day of trial, but none of them are valuations of the day of judgment.
The only thing I can suggest is that on the motion for new trial that was filed by Mr. TRETHEWEY, when he raised these issues of supposed changes because of the passage of time, and the judge made some findings because of this was right at the head of COVID and everything else that went into it in the 19 days of trial that it took.
Is Judge Ditkoff correct that the values that are in the judgment are from the last day of trial?
Yes, that's when
Okay.
the evidence closed, yes.
All right, so that's what we have. And do we have that, are those the values that were used in every instance with respect to the property from the last day of trial?
Yes, with the one exception that I think when they talked about dividing up by a qualified domestic relations order, the retirement accounts.
Oh, yeah, that
if there
would
was
be
some-
as of the date of judgment,
Yeah.
right?
So,
Okay, so, and is that okay under the case law? To leave it as of the date of judgment with the exception of the retirement account?
Last day of trial.
Sorry, as
last day of trial.
It's about the fourth time I've done that today.
That's okay.
Thank goodness he's here.
I understand what you're saying. My simple answer to that, and direct answer to that is yes, that's appropriate. Unless there is a request that it be made at a different time. In this particular case, Mr. TRETHEWEY was arguing that it should have all been valued at the date they separated, let alone date of trial, let alone date of judgment, let alone now he's coming in saying do it as of today. So, but yes, I say that that's the appropriate because that's all the evidence that the court has before it. And that changed evidence or alleged change evidence was presented on the motion for new trial. Judge has broad discretion to allow or deny or in part or in whole a motion for new trial. And in this case, she denied that. And she appropriately denied it. So I suggest that in all of the circumstances, and I will rest on my brief for anything we didn't address directly in the oral argument, the judgments be affirmed, and I appreciate your time that you've given me.
He says that he had an opportunity, he says he had no opportunity to address the $130,000 request for fees.
I think
Just
the record,
wrong about that?
I think yes, the record will show that there was put in place in this case. This is a case, there are 415 docket entries on the probate and family court docket. 415 docket entries. I do divorce, this next month I'll be starting my 43rd year. I've never seen a case with that like this. But in any event, that was on it. Judge Black had sat through 19 days of trial and countless motion hearings, et cetera. She knew the people, knew the players, knew the counsel that would be before her.
But she hadn't yet.
So she put in place.
Did they have an opportunity to say, I have looked at the request for $130,000 in fees, and I either agree with it or I disagree with it for the following reasons? Did they have an opportunity to do that? And how was it presented to them?
Essentially, yes. And the way that was presented, there was a gatekeeper order that was put in effect that basically said nobody can file any new pleadings in this case without the court's advance permission. There was a request for counsel fees filed. If you go back to her original counterclaim for divorce, she had requested, so that was filed.
Did they file an opposition?
Husband tried to file an opposition, and there was a hearing held on whether or not he would be allowed to. And during that hearing, the judge said, and I think the transcript is in the record, I've heard enough, I understand the issues, I can rule on it as part of the judgment, which I think
Isn't the problem that the judge allowed your motion, the wife's motion, and disallowed the husband's opposition and said, I think just the wife's view is enough?
But she wasn't relying on just the wife's view. She was relying upon her history with the case, her direct observations of it, and the arguments that were made at that hearing when she said, I've heard
And
what
that
I need to
would
hear.
be a lot more compelling if she had struck the wife's motion as well and said, I'm just going to do it on the trial stuff. But instead, she considers one party's pleadings and not the others. How is that acceptable?
I'm saying it, I don't think it was just the pleadings. I think it was her overall view and overview of this case and her handling of it.
I mean,
Any other context? Sorry.
If I said we're going to read all the transcripts, don't worry, but we're only going to take briefs from the appellants, not from the appellees, because that'll be enough.
That would be wrong.
Right, but why isn't this
would
the
be
same
wrong.
thing that happened here? She'll consider when they have it to trial, but only one side's pleadings.
But she heard the arguments during the decision to not allow the husband to file.
So that was my question.
Yeah.
Are you representing to us that husband's counsel had an opportunity at that hearing, which, as I take it, had a lot of technical arguments about whether they're allowed to file something or not? Did the husband actually have the opportunity to address the merits of the request for $130,000 in fees?
I'll rely on what's on that January, I think it was January of hearing that occurred.
Do we have a transcript?
Yes, it's in the
Thank you.
hearing.
All right, well, you've gone 7 seconds more than your friend, but I think I'm going to let it go at that point, if that's all right.
Thank you.
This is obviously a very complicated case, and we are going to, we're very grateful for the briefing and the argument here in this case. As long as I'm thanking people, I'd like to thank all the attorneys that were here today. I'd like to thank our court officer. I'd like to thank our timekeeper and certainly the clerk's office. I'd like to wish everyone a meaningful Armistice Day this weekend. And with all that, we will stand adjourned until Monday at 9:30 a.m. at the Campus Center at the University of Massachusetts at Amherst. The next sitting in this courthouse will be Tuesday at 9:30 a.m.
Thank you, Your Honors.
Thank you.